Yes, please.
Look, item 55, is per matter pertains to an auction of the e-auction of a property under surface act. We were the auction bidder, highest bidder. Well, they canceled, subsequently they canceled the bid. That is why we are before the court. But the meantime, my lord, we have a talk with the bank officials. My lord. But we'd like to withdraw this petition with a liberty to file a representation before the bank. And they will consider it, my lord.
In accordance with law, we will consider, no difficulty with that.
Mr. A. Samuel, learned counsel for the writ petitioner submits that subsequent to the filing of the writ petition, there was some discussions held with the held in between the petitioner and the officials of the bank who have agreed to consider a representation if filed by the petitioner ventilating its grievance in the matter, full stop. As such, the learned counsel for the petitioner seeks leave of this court to withdraw the writ petition with liberty to file appropriate representation. Full stop. Mr. A. Ganguly, learned counsel, appearing on behalf of the respondent bank, submits that he would have no objection if the prayer is allowed by this court. In view of the above, this writ petition stands disposed of on withdrawal with a liberty as prayed for. IA stands disposed of accordingly.
No, the interim orders passed earlier, will stand vacated.
Interim order passed earlier shall stand vacated. At hetu likhibo, IA stands disposed of in view of order.
Wait, please, your lordship. Under instructions, my lord, item number 8. May I withdraw with a liberty? Liberty would be necessary, absolutely, my lord.
Liberty,
With a liberty, my lord, to file again.
why you want to?
Because we challenge the action of the secretary in issuing the notice on the count that he's acting unilaterally. Now, if I withdraw this petition without a liberty, consequently the AGM would be held. I would have no right to challenge, my lord. Sarguja Road Transport would come in, my lord. That's
With liberty to do what?
to file again if need be, my lord.
Same cause of action.
No, not same cause. It will be the consequential cause of action. I challenge the action of Mr. X in issuing the notice for the AGM. Now, once I withdraw it, the AGM.
Mr. S. Banik, learned counsel for the writ petitioner submits that his client seeks leave to withdraw this writ petition so as to permit the AGM.
No, with the liberty to file if need be.
No, but AGM is fixed when?
2 AGMs are fixed. So far as we are concerned, we are fixed on 29th. So far as the other person is concerned, they're fixed on 30th.
So as to permit the AGM scheduled. AGM, permit the AGM to go ahead, but the learned counsel for the petitioner seeks leave.
No, that may not be there, my lord, to go ahead. What we are.
You wait, we'll see when the order matter reaches this.
Item 28 to 34. Well, there's a admission hearing matters, my lord. Item 28 to 34 regarding a tax issue. My lord, today the AG was supposed to appear, my lord. He is in bereavement. Can it be, my lord, on 10th of October? I've taken the consent from the other side.
No, it will go to November, October not possible. October is the before Puja holiday. We choose date in November.
Then, my lord, I will give a date, my lord, as per convenience to the court master.
After reopening of Puja holidays.
Yes.
Mr. B. Gogoi, learned standing counsel. Finance and taxation, your finance and taxation.
My lord.
Appearing for the respondents in these matters. This is item 27 to
28 to 34.
28 to 34. Submits that due to non-availability of the Advocate General Assam, learned Advocate General Assam, who is in bereavement, hearing of these matters would not be possible today. As such, the learned departmental council has prayed for adjournment in these matters with a request to post these cases for hearing again on
That I will.
leave it dot. The learned counsel for the petitioner is present. Petitioners is present and does not have any objection if the prayer is allowed. In view of the above, let these matters be listed again as fixed items. Again on. It will be a date after 7th of November. After 7th. Let it be 7th of November.
Date.
All right.
I will
After
provide.
7th November, whatever date. Any interim order here?
No.
No,
All right.
it's regarding refund only.
Lordship, my lord, item 54,
Hmm.
the state has filed an affidavit. We will file a reply. Lordship, may kindly fix the matter next week. I have taken consent of other side,
Who is the other side?
government.
Item you are mentioning
54 supplementary.
54. Mr. M. Mahmood, learned counsel for the writ petitioner submits that A copy of the counter affidavit filed by the departmental authorities has been served upon him, and therefore he will be granted a week's time to file rejoinder. Since the prayer is not opposed, the same stands allowed. Let the matter be listed again after the rejoinder is brought on record by the petitioners.
Obliged.
Yes,
May it please your lordship, my lord. I am a cooperative society, my license has been cancelled.
Hmm.
My lord, readings are over, my lord, and the noticeable date is also over, my lord. Can it come on admission on, my lord, Wednesday? Some urgency is there, my lord.
what is the urgency?
License is cancelled, my lord, I am,
Choose a date next week, next week. Next week, choose a date. Yes.
May I please, your lordship, I am praying for listing 4 motions, matter, my lordship, filed by the National Highway, my lord. This case relates to construction of National Highway, lordship. There is an order passed by the arbitrator, lordship. Now that post has been abolished, lordship. There is an interim order, lordship, that not to demolish the house of the petitioner, lordship. That private respondent has filed that arbitration petition for payment of adequate compensation, my lord. So due to that order, lordship, whole project has been stopped, lordship. There is 2 order passed by this court, lordship, already stayed the proceeding, lordship. Another 4 cases are there, lordship. So may I pray for tomorrow, lordship.
Day after tomorrow. Why tomorrow? Tomorrow is not a.
My lord,
working
my
day.
lord, my.
Yes.
Lordship is, I think 21.
Hmm.
Your lordship, I appear in the writ petition as the petitioner. I've been served with an improvement application just now in the morning. I'm seeking 2 weeks' time because I appear for the department, which is the provident fund.
Item,
21.
yes, you are appearing for whom?
The Assam team, opposite party 9 in this IA.
Yes, so you want time to file?
Yes, they have filed an
Rejoinder.
application before, but it's been served to me just now in the morning. So I need some time to,
This application is,
it's been filed for improvement of one of the private respondents, which is Borhula Tea Industries. I have
so
to,
this IA has been filed, this is an IA or?
yes, it's an IA 2614 of 2013,
IA is in the list.
23, sorry,
It is in the list, it is listed. today.
yes. But unfortunately not served,
All
today. I
right,
only got it today morning.
Heard Mr. R.J. Das, Larik Council appearing for the applicant. Also heard Mr. R.B. Fukan, Larik Council appearing for the OP read petitioner. So read petitioner will submit, submits that a copy of the IA has been served upon him only this morning. And therefore, 2 weeks' time be granted for obtaining instruction and granting objection. The prayer is not opposed by the applicant's counsel. Mr. A. Ganguly, learned counsel, is present on behalf of
The respondent number 3 bank.
respondent number 3 bank and does not have any objection if the matter is adjourned. As such, let this matter be listed again after 3 weeks, along with the objection, if any, filed by the
Great,
OPs.
extremely great.
May I please, your lordship? I would like to mention for listing of a fresh IA, lordship, for amending the cost title. Lordship, may take up it on Wednesday, lordship. Obliged.
May I please, your lordship? Lordship, I beg to mention item number 40. Lordship,
40.
40, lordship. Lordship may not take up this matter, lordship.
Let's prefer any other court without me. They're gonna move on to duty.
Obliged,
Yes.
lordship.
May I please, your lordship, so due consent from other side, I beg to mention item number 42, your lordship. This
Hmm.
matter, lordship, we have received pairwise comments. I may be allowed 2 weeks' time to file my affidavit, your lordship.
Mr. R.S. Mr. Learned Counsel for the petitioner is present. Ms. R.M. Deka, Learned Standing Counsel, GST
Yes.
authorities submits that she has just received instruction in the matter and therefore be granted how much time?
2 weeks'
2
time.
weeks' time to file affidavit. Since the prayer is not opposed, same stands allowed. Let this matter be listed again after 3 weeks, along with the affidavit, if any, filed by the respondents.
But there's an interim order, madam.
Interim order passed earlier to continue until further orders. Yes.
Please, your lordship, read petition pertaining to land acquisition, lordship. The matter was in fact fixed for order on 8/5/2023, but not listed since then, lordship.
Hmm.
Lordship, it may
What
come-
order is required?
Lordship, I have make a prayer for interim stay, but lordship observation was that my interim stay would be considered on the next returnable date. The matter was in fact a fixed item, but not listed since 8/5.
You put a date next week. Next week. Yes.
May it please, your lordship. Lordship, I am praying for listing one admission matter next week, any date, lordship.
What is the matter?
Settlement of landlord. Lordship.
Settlement of land, what is the urgency? Mentioning is to be done only in urgent matters.
Lordship, it is a
If you
last,
mention every matter, then the answer will be rejection in every matter.
lordship, last listed.
You ask your senior why mentioning is permissible. Mentioning is permissible only to let out of turn matters to be listed. So don't mention a case which is not urgent. Urgency means every case you would like to be finished early, but that's not urgency. Urgency must be in the case, not your personal urgency. So you come back, ask your senior and come back. If you still think there is urgency, we'll consider. Come back day after tomorrow after asking your senior.
Daily list for motion item 1.
My lord,
Which order?
my lord, page 7, my lord, order dated 1/3/2023.
What action has been taken?
My lord, page 10,
Page 10.
third notice has been issued, my lord. Order was passed on 1/3, third notice issued on 7/3, my lord. And they have received, they have accepted the notice as well, my lord. On 1/3.
So F Khan Dibla order notice issue for 8 weeks. Respondent. Respondents, multiple respondents, registered post. Step.
Obliged.
Item 2.
May I please, your lordship.
8 weeks.
Operative portion of page 8, my lord, last portion, last paragraph, my lord. Ex gratia, my lord, order, my lord. Time has elapsed, my lord.
So what has happened? It has not been done.
No.
W Rahman did 8 weeks here.
Item 4.
May I please, your lordship, my lord, petitioners are from backward, my lord, scheduled caste community, my lord. They are in possession of a particular plot of land since 1954, my lord, from the days of their grandfather, my lord. In the meantime, my lord, they submitted application before the authority, my lord, for allotment, settlement of the particular plot of land, my lord. Thereafter, in the meantime, my lord, on 6/8/23, my lord, a notice has been issued, my lord, eviction notice has been issued. So, I'm challenging the same, I have approached this.
8/6/2020.
Yes, my lord.
Where is the eviction notice?
Page 56, my lord, annexure F. my lord.
What is the ground of challenge?
My lord, no description of the land for what purpose it is reserved, my lord. Nothing is there, my lord. Kindly see, my lord, notice. Page 56. my lord. No opportunity of hearing also, my lord, has been given to the petitioners, my lord.
Yes, Mr. Sharma, what do you have?
Lordship, we have received certain instructions. From that instructions, it reflects that Doug number 7725 is a PP is a private land of a PP number 67, but Doug number 833, it's a government khas land where lordship, the red flag was already marked. According to our record, lordship, he is not an occupant of this 833 Doug number.
Why don't you give him an opportunity of being heard? He is occupying the land since when?
Lordship, that can be.
Yes,
Occupying the land since
1954. my lord.
both the cases.
Yes, my lord, in both the cases.
And the date of notice is same.
No, my lord, in a real case, my lord, in that case, my lord, for allotment of particular plot of land. my lord.
And
There
there
was
was
that for
a
allotment.
civil case was also, they have instituted a civil case, lordship, that was also dismissed by them. The civil suit
Civil suit was for what?
was initiated against by them, lordship.
Between private parties.
That was also dismissed, lordship.
So, Mr. Chauhan, what is your case now? What is the problem? You are occupying Sarkari land.
Yes, my lord.
Then
Since
you have to
19
vacate it.
my lord,
Then you have to vacate it. That's all.
My lord, there is special provision for the scheduled caste community.
What is that provision?
In the land policy 1989, my lord, it was 1989 land policy, 16.3. The scheduled caste and scheduled tribe landless eligible persons occupying government land shall be given settlement of the land under their occupation if the land is not otherwise reserved for any specific purpose, public purpose. In case the land under their occupation is needed for any public purpose, alternative suitable land shall be given settlement to such persons before the land under their occupation is taken over for the public purpose. That was there, my lord, in 1989 policy.
This policy is still in force.
My lord, thereafter 2019 policy is also there. my lord.
What does the 2019
It
policy?
is also, my lord, the approximately similar provision is there, my lord. The indigenous 1.7 clause, my lord. Indigenous landless cultivators. Preference will be given to the landless indigenous cultivators belonging to scheduled caste, scheduled tribe, and OBC, more OBC communities.
Pass on the book. So, and the next read petition by the same petitioners
Yes, my lord. For-
seeking
that is
allotment
for-
of land,
Yes. ma'am. Good, ma'am.
which was filed earlier.
My lord, 3076, my lord.
This is agricultural land.
Yes.
Is it so, Mr.?
Our,
Yes.
as per existing land records, the land covered by Doug number 725 at village Upohupara under Rangamati Mouza, Mongoldoi Revenue Circle is a private land, and the concert Latmondol and Gao Pradhan placed the red flags in government reserve land covered by Doug number 833 at village Upohupara and not on Doug number 725 as mentioned by the complainant.
No, that is not the point. Point is, he's saying that they are all
Lordship.
scheduled caste, people belonging to scheduled caste
Lordship.
category. And
So
they are
did they-
occupying the land since, government land since 1954. So as per the land policy, they are entitled to settlement.
Entitled, Lordship, under
And
that
they have
policy.
already applied for settlement of land.
So let there be a hearing, Lordship, within a period of 1 month, let that be the disposed of, Lordship. That will be better, I think.
Yes.
It's because the other things also there, Lordship, whether they are landless or not, Lordship, whether.
Eight petitions, equivalent, same order. Heard Mr. R.S. Chauhan, learned counsel appearing for the writ petitioners in both these writ petitions. Also heard Mr. H. Sharma, learned additional government advocate Assam appearing for the state respondents. First up, Ms. G. Hazarika, learned SC Revenue, is present on behalf of the Revenue Department. Full stop. The writ petitioners hearing claim to be landless persons and have been in occupation of the plots of Sarkari land in question through their ancestors since the year 1954.
Yes.
According to the statements made in the writ petition, the petitioners have been cultivating the aforesaid plots of land for eking out, eking out a living. Full stop. The petitioners had also submitted applications. No, take down. Since the petitioners are landless persons belonging to the scheduled caste communities, they had also submitted applications before the district commissioner.
Yes.
Bracket erstwhile deputy commissioner, bracket close, Darang district, seeking settlement of the land in their favor. And the said application is pending disposal before the concerned authorities. Notwithstanding the same, the impugn notice dated 8/6/2023 has been issued by the circle officer Mongoldoi, directing the petitioners to vacate the land. Aggrieved thereby, WPC number 3929 of 2023 has been filed by the petitioners seeking an order of protection from this court. The same petitioners have also filed WPC number 3076 of 2023 seeking a writ of mandamus directing the respondents to consider their prayer for settlement of land and in the meantime protect the possession of the petitioners over the land.
Yes.
Full stop. By referring to clause 1.7 and the explanation thereto of the Assam land policy of 2019, Mr. Chauhan submits that it is incumbent upon the administration to settle land with landless persons belonging to the SC/ST/OBC communities by giving top preference to their applications. Notwithstanding the same, no action has been taken on the application submitted by the petitioners for settlement of land. On the contrary, an attempt has been made to evict the petitioners by issuing the impugned notice, although the notice neither indicates the boundary of the land, nor does it mention the purpose for which the reserved land is required by the state. Full stop. Mr. Chauhan, however, does not dispute the fact that the petitioners are in occupation of Sarkari land. Full stop. Mr. Sharma submits on learned additional senior government advocate Assam submits on instruction that the land under occupation of the petitioners is admittedly and evidently a Sarkari pertains to a Sarkari das. Full stop. The learned government advocate, however, has submitted in his usual fairness that having regard to the facts and circumstances of the case, as well as the clauses contained in the Assam land policy of 2019, the petitioners can be given a hearing before any further action is taken in the matter. Similar is the stand of Ms. Hazarika, learned standing counsel, Revenue Department, Assam. In view of the above, without expressing any opinion on the claims and counterclaims of the parties, as with the consent of both the sides, these writ petitions have been disposed of by granting 2 weeks time from today to the petitioners to submit a fresh representation ventilating their grievance in the matter before the District Commissioner Dharam, Mongoldoy. If such a representation is submitted within 2 weeks, the same be considered objectively and disposed of by a speaking order within as expeditiously as possible, preferably within next 8 weeks. First of all, until such time, the aforesaid exercise is completed. Status quo as regards the possession of the petitioners over the plots of land in question be maintained. About the
If they fail to make the representation, Lordship,
then this is known, law will take its own course.
Yes.
With the above observation, both the writ petitions stand disposed of. Yes.
Item 5.
Yes.
Made clear, Your Lordship. My lord, petitioner is in company registered, having a registered office in Punjab, my lord. Petitioner is engaged in the activity of construction of roads and repairment of public roads, my lord. And is thereby exempted in lieu of the notification dated 25 of 2012 under NT 13. So sometime in the year in financial year 16-17 and 17-18, petitioner had done a small work in Assam Chabua airport. Probably they have extended something. For that particular period, they had taken service tax registration and subsequently they had surrendered its registration. So thereafter, my lord, in the year 2022, by invoking section 73 of Finance Act, my lord is aware there are certain conditions for extension of 73. A show cause notice has been issued to me by stating that and penal that service tax of 5 crore 13,66,354 is payable. And thereafter, I had submitted my reply. In my reply, I have specifically pointed out, my lord, that the assessing authority does not have any jurisdiction to try this matter for two good reasons, my lord. Firstly, I am registered in Punjab. I have my registration, my registered office in Punjab. Secondly, the work which has been done, my entire bunch of work. So what is also in outside the territorial jurisdiction. So what they have done basically, they have picked up my 26 AS, my lord, and they have seen from my 26 AS around a 30 crore work has been done in a 2 financial year. Based upon that, they have issued a show cause notice of 5 crore 13,66,354. Thereafter, my lord, I submitted my reply, attended the hearing. I explained this point that you do not have any territorial jurisdiction. Neither, as because I am an exempted entity and my services are exempted, you cannot impose any tax upon me. This all submissions were rejected, my lord, and order in original has been passed. Now, order in original, my lord, will find in the page number 61. Now, my lord will turn to page number 62. And my lord will see in para number 1.2.
Yes.
So as per AS form 26 for FY 26, 16, 17 and 17, 18, it appears that said notice is standard taxable service totaling to 34 crore 24 lakhs 42,356. And on such value, service tax amounting to 5 crore 13 lakhs 66,354 rupees has been levied. My lord, how they have calculated this figure is there. Now, my lord will see how
The petitioner company is from Punjab
yes, my lord.
and your business activities are in Punjab, or it is also?
It is basically we are in a company who are mainly concentrated in Punjab. We had done few works here and there in India, other parts of India. One construction of Tabua airports, some road we have constructed. That is how he is invoked. Now that my lord will find in the page number. My lord will find that in 71, my lord, for a moment, my lord will turn to page number 71. So what he does in page number 71, my lord, he gives this breakup of the 34 crore, which my lord has seen in the previous pages of 62. Page number 71 for a my lord, for a moment. Now, before how it starts, in page number 70, it starts at para number 5.02. The allegation in the show cause notice and counter reply of the said notice have been carefully examined. I find that the alleged taxable value of rupees 34 crore 24 lakhs 42,356 have been taken from AS 26 of the notice for the financial year 16-17, considering the date of transaction for the period of October 2016 to March 2017 for the FY 16-17. And for April 2017 till 30th of June 2017-18 was shown below. He tabulates all the transaction, my lord. My lord will see, apart from transaction number 16, my lord, apparently which is a value of 25 lakhs in the FY 16-17, and in the table number 2, the value of only 44 lakhs and 147 lakhs. My entire 34 lakhs is from outside territorial jurisdiction of this honorable assessing officer, my lord. He himself mentions. He gives the exact breakdown, my lord.
1 minute. This order is of March 2023.
Yes, my lord.
Now, you have come after.
My lord, I have filed the petition.
Can you explain the delay?
No, my lord. I actually filed I had approached this honorable court, my lord, on 21st June 2023. I had filed. This matter had come once before, my lord. This matter was supposed to be argued by one counsel from outside. Mr. Satija, he could not. On the last occasion, I had prayed before my lord. On the last occasion.
Let me see. When did you file the writ petition?
21st June 2023, my lord.
No, it's showing July. Anyway, so you are challenging this order.
Yes, my lord. I am challenging this order. So thereafter, my lord. I'm so sorry, my lord. I will not take too much. So if my lord will just turn to the findings, how he has recorded this finding, that finding you will, my lord, will find in page number
Mr.
70.
Day, when the court asks the respondent's
sorry,
counsel to respond,
My lord,
that means it's time to sit down.
my lord,
Please understand these basic
my lord,
norms
answer,
of practice. Yes.
Lordship, may I please, your lordship, Lordship, in fact, this order is appealable, your lordship, page number 61, your lordship.
No, but what is your answer to, how can the Dibrugarh Commissioner levy this kind of penalty over his overall, is there nothing called jurisdictional, territorial jurisdiction in
Yes,
your GST regime?
let me to take instruction, your lordship.
Then we'll have to stay. Heard Mr. A.B. Dale, counsel appearing for the writ petitioner, peruse the averments made in the writ petition. The order dated 23/2023, issued by the Principal Commissioner. Principal Commissioner of the GST authorities. Having his office at Dibrugarh in the state of Assam. This writ petition has been filed inter alia contending that the order of penalty levying a sum of rupees
5
5,13,66,354 on the overall alleged business transaction of the petitioner, which is operating out of state of Punjab is wholly illegal and arbitrary. The impugned order has been primarily assailed on the ground of want of territorial jurisdiction on the part of the Principal Commissioner, that is the respondent number
2, my lord.
2 hearing. Mr. Day has further argued that his client is engaged in services which are exempted from the purview of GST.
GST.
Moreover, the figures arrived at by the respondent number 2 are wholly imaginary and does not have any concrete basis. Full stop. Responding to the above, Ms. R.M. Dekar, learned SC GST, prays for 6 weeks time to obtain instruction and file affidavit. Similar the stand of Ms.
P. Sargari for respondent 1 on behalf of SK Medhi.
Similar as the stand of Ms. P. Sargari appearing for the learned CJC, Mr. P.K.
SK Medhi.
S.K. Medhi. Full stop. In view of the above, issue notice of motion returnable in 6 weeks. Since Ms. Sargari has accepted notice for respondent number 1. You are 1 and 2 or only 1?
Is only for 1, your lordship. I am
Take
for
only
2.
1, and Ms. R.M. Dekar has accepted notice for respondent number 2. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisitive numbers, be furnished to the learned department council so as to enable them to obtain instruction and file affidavit. Heard on the prayer of interim relief. Having regard to the facts and circumstances of the case, it is hereby provided that no consequential action shall be initiated by the respondents based on the impugned order dated so and so until further orders.
Deeply obliged, my lord.
Item 6.
My lord, may I please to pass up the matter for time being, my lord. Counsel Mr. B. Gogoi is occupied in court number 6. He is appearing for this matter, my lord.
Item 7.
In item 7, Lordship, before start my learned friend, Lordship, he is relying on the Board of Revenue's order, Lordship. That order is missing in our petition.
My lord, I have already, anyway, well, I will find it after.
Furnish him a fresh copy. We'll have it on Friday. Mr. S. Samaria, learned counsel for the petitioner is present. However, Mr. H. Sharma, learned additional GA Assam appearing for the senior government advocate Assam appearing for the state submits that the writ petition, copy of the writ petition furnished to him does not contain the impugned order. Since Mr.
Not the
Sharma-
impugned order, on the basis of the order of the Revenue Board, they are claiming their right over the plot of land, Lordship. That order of the
does
Revenue Board is not available.
Contain the order of the.
Yes,
Revenue
tomorrow
Board,
9 again.
based on which the petitioner is asserting her claim. Since Mr. Samaria has assured this court to furnish a corrected copy of the writ petition to the Learned Department Council during the course of the day. This matter stands adjourned and shall now be listed for motion again on Friday, day to be due,
Well.
by reflecting the name of Learned Council for all the both the sides in the province.
Manad, I had a word with my clients. They said that the cause of action has been negated by the authorities by subsequent order. In this view of the matter, you to withdraw.
Mr. S. Banik, Learned Council for the writ petitioner submits that in view of the subsequent developments happening in this case, the writ petition has been rendered infructuous. Therefore, the petitioner be granted leave to withdraw the writ petition with liberty to file afresh as and when a proper cause of action arises. Mr. V. Rajkumar, Learned Standing Council Corporation Department, Assam, appearing for the respondent numbers
1 to 4, Your Lordship.
1 to 4, and Mr. A.V.T. Hoff, Learned Council appearing for the respondent number 6 are present and do not have any objection with the prayer allowed. In view of the above, this writ petition stands disposed of on withdrawal with liberty as granted.
The matter relates to compensation, my lord, since government circular is there, my lord, that is a space 27, 28. My lord, 2 lakhs rupees, the person who died in the motor accident in the public place is entitled to government. In this regard, my lord, already this honorable court has already passed the order. Lordship will find.
Mr. Chetri, we'll just give them a short time to obtain instruction and dispose it of on the next day. That is the procedure I'm following in this course. All right. So just wait for a short time. We'll give a date before vacation. Heard Mr. B. Chetri, Learned Council appearing for the petitioner. The petitioner is the wife of Mrs. Nanu Pradhan, who died in a motor accident on 15/8/2022 while riding a scooter. First up, as per the government circular dated
15/11/2014.
15/11/2014, the petitioner was entitled to ex gratia relief of rupees 2 lakhs due to the premature death of her husband in a road accident. However, since the representation submitted by the petitioner to that effect has failed to evoke any response from the district administration, the instant writ petition has been filed. Mr. Miss N. Bordoloi, Learned Standing Council Revenue Department, Assam, has paid for 3 weeks' time to obtain instruction facilitating disposal of the writ petition. In view of the above, issue notice of motion returnable on 18th of October, 2023. Since Ms. Hazarika has appeared and accepted notice. for
Lordship, I'm
respondent-
N Bordoloi.
Sorry, N. Bordoloi, Learned Standing Council, Revenue Department, Assam, has appeared and accepted notice for respondent number 1. Mr. B. Gogoi, Learned SC Finance for respondent number 2, and Mr. H. Sharma, Learned Additional G. Assam for respondent numbers 3, 4, and 5. Service of notice is deemed to be complete in this case. Extra copy of the writ petition, requisite in numbers, be furnished to the Learned Department Council within 3 days from today, so as to enable them to obtain written instruction facilitating disposal of the writ petition on the returnable date. We'll finish it off. in there.
10 is also same.
Same is.
Parties are- and what is the person is also same? No, let's see.
Here is the wife, Ranju Saikia, my lord. She has submitted, her husband was Tilak Saikia.
Tilak Saikia
Yes.
died in accident on 4/6/2019
4/6/2019.
while riding a scooter. So these are the two persons were in the same scooter.
Lordship.
এই যে বাকি কি নিয়ে কি আছে? Silent.
No, not same.
scooter,
Not same.
same
Different
Different.
incident.
location, same.
Different.
এই part টা change করে দেবো, riding a scooter, scooty.
Obliged.
Like.
My pleasure, Lordship. Lordship, please, victim compensation.
matter is.
What victim compensation, what? Lordship, take down her.
Make the-
Your name, please?
R.I. Mandal.
Mr. R.I. Mondal and counsel for the petitioner. The writ petition pertains to prayer for payment of victim compensation. I peruse the grounds taken in the writ petition. NOM 8 weeks since Ms. S. Sharma, learned government advocate Assam, has appeared and accepted notice for restaurant number 1. And Ms. R.M. Borua, learned SC Finance Department Assam for respond number 2. Service of notice on respond numbers 1 and 2 is deemed to be complete in this case. Have you served copy on Secretary DLSA?
Secretary.
Have you served copy on Secretary DLSA?
Secretary DLC.
Have you served?
Yes.
When?
Short notice.
Petitioner to take steps for service of notice upon respond number 3, 4 and 5 by registered post within a week from today.
Obliged.
Matter relates to non-granting of sale function, my lord. My lord, petitioner, number 1, my lord, she is the owner of a land measuring 1 bigha, 1 katha, 6 deciles. And she proposed to sell a portion of that land that is about 3 katha 10 lesa, my lord. They made an agreement with respondent number 2 for selling the said land, and sale permission was applied.
She has
But-
entered into an agreement with respond number 2.
Oh, no, my lord, sorry, my lord, petition number 2. Petition number 2. And my lord, thereafter, when they applied, they found that there is objection. And on inquiry, they found that is daughter of the petitioner has filed a title suit. And in that title suit, injunction has been granted in respect of a land measuring 2 katha 10 lesa. So we made an application that since there is injunction only in 2 katha 10 lesa, so the remaining.
No, it cannot be done.
Because
It cannot be done. You
Dark
get the
number-
clarification from the civil court. It cannot be done. Whoever has given this advice is not conversant with the civil law. You can't say that since injunction is so much, this much will sell. We
But
cannot
it-
direct the administration to do that.
no, because my lord, the schedule is given, my lord.
All right, we'll issue notice, but if you don't follow what the court is saying, it will cause harm to your client, as simple as that. We will not do things which are not correct. You may submit. You get a clarificatory order from the civil court. That's the only way out.
But my lord. civil
All right,
court-
I heard Mr. I. Chaudhary, Learned Counsel appearing for the petitioner. There was the amendments made in the writ petition. The petitioner number 1 is proposing to sell a plot of land to the petitioner number 2. However, since the permission for sale has not been granted by the district administration, the instant writ petition has been filed. It appears that due to some objection raised by the daughter of the petitioner number 1, pertaining to a pending civil proceeding, the permission has been withheld. Be that as it may, considering the amendments made in the writ petition, the matter would call for further examination. NOM 6 weeks. Since Mr. H. Sharma, learned additional senior government advocate Assam,
1, 3 and 4.
has appeared and accepted notice for respond numbers 1, 3 and 4. And Ms. G. Hazarika, learned SC Revenue Department Assam for respond number 2. Service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned department. But why do you do all these things? We
No,
don't
my lord,
understand.
but-
This is just going to delay your client's cause.
But
There can't be a mandamus directing the DC to grant permission, ignoring the civil court matter. As simple as that.
the civil court is in respect of 2 katha 10.
Why don't you get the clarification from the civil court?
Actually, my lord, they have filed a title suit for specific purpose of contract only in respect of 2 katha 10 lesa, not the
Okay,
entire
okay, okay.
plot of land.
Fine, fine. Very good. You wait till another 3 years in this court.
May I please, your lordship. Lordship, victim compensation. Make the notice.
It's the same order as about victim compensation. Similar, same order.
Lordship.
Obliged.
Error of party side of it.
এইটো তোমাৰ নামত লৈ
Fourteen.
Earlier one is 11, item 11.
Wait,
Yes.
my lord. My lord, this, and before your lordship, there is a title suit order, my lord, in favor of the petitioners, but yet they are disturbed from the forest officials along with some other, nobody having no right on that property. Coming and disturbing, complaining the forest beat officer, they come and they disturb them. There's lots of hue and cry. I have even tried to bring with your lordship all the photographs and all and recordings and all, but there is a certificate, they are testamentary landholders of that area. The forest officials somehow are disturbing them. That is the whole crux of the matter. The beat officer along with some others, with many land verification and all, they are the testamentary holders there in that land. From paternal, their paternal property.
What is the relief? you are
Well,
seeking?
this is a forest land. They are forest villages. There is a regulation in force, but these lands, my lord, original, it's are not transferable, my lord. So, my lord, I have orders from this honorable court, my lord, whereby similar prayers were rejected, my lord. I can bring them on the day after tomorrow, my lord.
All right, we'll have it on then Monday, next Monday.
Yes.
Next month.
Till next Monday, don't take any
My
action.
lord.
here.
Yes.
Till next
I heard Ms. D. Sinhalani, counsel appearing for the petitioner,
Thank you.
approves the amendments made in the read petition. Mr. Gogoi submits that there are already orders passed by this court covering the issue, and therefore he be granted time till Monday, that is, give the date, not Monday. it is-
Monday is 2nd
All
October,
right, let it be third.
3rd.
October 2023, so as to enable him to produce those records before this court. Since Mr. Gogoi has given an assurance that no action will be taken against the petitioners till the next day, his read petition is directed to be posted again on 3rd October. You are available?
Yes,
You want 3rd or 4th?
third.
3rd October. For motion.
May I please, similar matter, my lord.
List
Similar
along,
forest village.
item 14. List along on
My lord.
3rd.
3rd, my lord. Always, my lord.
Item 16.
He'll produce the orders. and
I'll
then
produce orders.
May it please your lordship. Petitioner before Lordship is the one of the beneficiary of Pradhan Mantri Awas Yojana Lordship, and his name has been struck down Lordship. And Lordship, thereafter he has submitted his several representations before the concerned authorities Lordship, that those were not considered
His
Lordship.
name was struck down when?
Lordship, initially his name was included, but
I am asking, his name was struck down when?
when
You are
Lordship.
telling me when his name was
Yes,
included.
Lordship,
What sense does it
at
make?
the time of when the list was sent to the block development officer, Lordship, at that, and when the list was published, he could not find his name there, Lordship.
When was the list published?
In the year, Lordship, 2020, Lordship.
So after 3 years, he has come to the court.
Lordship, thereafter, he have filed RTA applications,
Hmm.
and that RTA reply, he did not get the RTA replies.
Where is the RTA application? Let us see.
Lordship, RTA application, Lordship will find at page 21, Lordship. And those, he did not get any replies, Lordship. Thereafter, he again filed an appeal before the DC.
Just a minute, just a minute. So here you'll have to file affidavit. We'll issue notice at this stage. That's-
Or Lordship, at this stage, my reposition may be disposed of, Lordship. The reposition that I submitted before the principal secretary, Lordship, on 24/6/2023, Lordship.
No, what representation is that? First, let us
Yes.
find out what is, what they have, whether your name was there,
Yes,
whether it was deleted.
yes, Lordship.
All right, you file affidavit. Heard Mr. S. N. Krishnapriya, and counsel appearing for the writ petitioner. The petitioner herein claims that he belongs to the BPL category. And therefore had applied for homes constructed under the Pradhan Mantri Awas Yojana bracket PMAY bracket close scheme through the 67 number Kyutkuna Gaon. This I was willing to use. Kyutkuna Gaon Panchayat in South Karimganj, in the district of Karimganj. First of, according to the writ petitioner, originally his name was included in the list of beneficiaries, along with other similarly situated persons. But when the final list was published, his name did not feature in the list of beneficiaries. Petitioner has made several representations, including filing RTI queries under under the Right to Information Act 2005, seeking the reason for non-inclusion of his name in the list of beneficiaries. However, till today, no response has been received by the petitioner. As such, he has been compelled to approach this court by filing the present writ petition. If the allegation made in the writ petition turns out to be correct, then there can be no doubt about the fact that the petitioner would stand discriminated in the matter of allotment of PMAY scheme. Therefore, affidavit on behalf of the respondent authorities would be necessary for disposal of this writ petition. Mr. N.K. Devnath, Learned Standing Council, PNRD Assam, and Ms. S. Sharma, Learned Government Advocate Assam, have both prayed for some time to obtain instruction and file affidavit in the matter. In view of the above, NOM 6 weeks since Mr. Devnath has accepted notice for respondent numbers 1, 5, and 7, and Ms. Sharma for respondent numbers 2, 3, and 6. Service of notice is deemed to be complete in this case. 2, 3, 4, and 6. Yes. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the Learned Department Council so as to enable them to obtain instruction and file affidavit. Let the matter be listed again after 6 weeks for admission. Deeply advised.
May please, Your Lordship. The petitioner before Lordship, they came before the Honorable Court for illegal and unauthorized acquisition of land, my lord. And thereafter, my lord, we came before the Honorable Court, my lord. Please may kindly see page 37, the PIL, my lord. There's the order, my lord. Page 39, my lord. Page 37, Annex 5, in the operative portion, page 39. May I read, my lord? We have heard so and so. Prima facie, we are of the view that petitioner here involved the dispute question of fact. The petitioner have clearly stated their pleadings that before approaching the court, they have submitted detailed representation to the Deputy Commissioner Kasar, as well as the General Manager SID, NHIDCL. However, it is alleged that their complaints have not been disposed of till date. In view of the peculiar facts noted above, we hereby direct the Deputy Commissioner Kasar, as well as the General Manager NHIDCL to objectively consider the representation submitted by the petitioners and to pass reason and speaking order thereupon within a period of 4 weeks from the date of submission certified. In case any adverse order is passed on the representation petitioner, they shall be liberty. And thereafter, my lord, what happened, my lord? Deputy Commissioner, page 46. After hearing page 46, my lord. Page 46, Annex 10, my lord. After hearing, given the opportunity to ask, along with my lord and National Highway Authority, my lord, and appeared, and thereafter and pass an order, my lord. Fourth paragraph, my lord. The petitioner has also stated the proposed alignment is not proper as per the Google map. So and so he also stated that proposed acquisition land is under process. Acquisition not is on northern side only, but the representatives of the so and so seal informed that land is under process of acquisition both sides of the road as per DPR. Seal also stated that to avoid mere carving, the proposed route is being acquired more so and so. The petitioner stated that notification 3 kathas land his own is given, but actual 8 kathas land being acquired. Seal informed that the actual land under the process of acquisition will be determined by LR staff as per DPR so and so and necessary addition and so and so. Considering the above, I am of the opinion that necessary corrigendum clarifying the portion of the proposed route fall in so and so may be notified specifically. I am also of the opinion that alignment the proposed 4-laning Silchar Bharaj Gate route is a technical matter, hence so and so required to take up a matter of correndum clarified as specifically NH which is involved in the proposed route by issue the notification. Further, so and so the necessary is also requested to look into the matter, and without considering the deputy commissioner, we are satisfied that my lord, they issued another order without considering the same my lord. Before that, they pass an order without giving the opportunity page 42 my lord. Without deputy commissioner order my lord, without anything, well, they had also represented, but before deputy commissioner order my lord, they pass an order page my lord 42 my lord. On 14/6/2023, without hearing, without any manner, they just straightway rejected our prayer, my lord. In spite of that, deputy commissioner passed an order by passing the correndum, but they did not do it, my lord. Before that, my lord, they issued the order, my lord.
What is the order about?
Order, my lord, please may kindly see page 42, my lord.
No, please come to the operative part. What is the order really? I have not understood. What really is the order passed by NHI?
Page 43, my lord. From 3, my lord.
Mr. Bora,
My lord.
what is the order? Why don't you tell me? Otherwise, I will come reading after 2 weeks and we'll see. You are not presenting the facts properly. What really is the order? You are only saying there is an order, there is an order. What is the order?
The order passed by the my lord in General Manager PM S. Silchar
All right.
DCL.
You obtain instruction, we'll have it after a week. After a week, later obtaining. You are not telling what is the order. You are telling who has passed the order, when it is passed,
Yes, ma'am,
which
that's
page
why,
it is,
that's
which
why.
annexure is it? I am asking you 3 times, what is the order? You are not.
Sorry, my lord, that, my lord,
All right, let me obtain instruction.
my prayer is that without considering the deputy commissioner order, my lord.
What is the order? And now I will ask you this question again next.
Order, page,
You have not,
page 44.
what
my
is
lord.
the order?
Order was
Look at
passed
me, what is the order?
by rejecting our.
What is the order?
Our representation was rejected.
What was the representation?
Representation is but my lord, as per their my lord, the Google map as well as by order my lord, both side, left side and right side 3.8 meter maybe, but only northern side. they
So
were doing.
did the general manager consider the corrigendum, the deputy commissioner's order? Otherwise we'll set
No.
it aside.
Let me take instruction.
Yes. Why don't you tell the basic facts,
Yes,
going
sir.
here, going there?
My lord, my and
You are a seasoned, experienced
My-
counsel.
my
You are
lord,
one of these upcoming senior counsels
My
now
lord,
almost.
15.33 my lord, 50, but 3.5 meter
No,
both
no,
side,
no,
but they did
you
not do
must
it.
be to the point. When the
My-
court asks a question, give a pointed
Yes,
reply to
Yes,
that.
my lord. Yes, my lord. Page
Stop this
44,
business of going here and there.
page 44, my lord.
Sit down. Mr. N. Bora, learned counsel appearing for the writ petitioner has invited the attention of this court to the impugned order dated 14/6/2023. Issued by the General Manager bracket P bracket close PMU Silchar, NHIDCL to submit that despite the categorical directions passed by this court by order dated 10/5/2023 in connection with PIL number 33 of 2023 and notwithstanding the order dated 6/7/2023 issued by the additional deputy commissioner Kachar issuing a corrigendum as regards the correct alignment of the road as per GPS coordinates. The impugned order dated so and so, impugned order dated 14/6/2023 has been passed rejecting the representation of the writ petitioner, thus causing serious prejudice to the interest of his client. First up, after going through the writ petition, this court had made a query with Ms. R. Bora, Learned Standing Counsel NHIDCL as to whether the order dated 14/6/2023 was reviewed after the order dated 6/7/2023 was passed by the ADC Kachar, or is there any proposal to review the said order in view of the corrigendum proposed by the district administration? Responding to the above, Ms. Bora seeks posting of this matter again on 4th of October 2023 so as to enable her to obtain instruction. prayer allowed. List this case for motion again on 4/10/2023. Two extra copies of the writ petition each be furnished to Ms. Bora and Ms. S. Sharma, learned government advocate Assam, so as to obtain instruction from their respective authorities responding to the query made by the court. Let them first obtain instruction. You are for whom?
And transport department and former purpose.
All right.
In their PL also, they have made us party, but no copy was served to us.
No copy was,
No copy was served to us.
No,
And
I'm
if they
sorry,
had
sir.
ever-
no copy was served. Why?
Which are,
No
How many,
copy
how
was
many
served to
copies
us.
you want? How
And
many?
it's just for the transport
What, how
department.
many you want? How many?
Transport one or so.
Only one. Give her one. She wants only one copy.
that today itself, two copies. will
Mr.
come.
Bora,
I'll-
apart from other things, you are not giving her a
I'll-
copy.
till then, my lord.
She is very offended.
Definitely always offended.
You must give her
Well,
copy.
till then, my lord, no action.
No, they, what action? What
Well,
action?
Otherwise, they are going to demolish the wall.
They will demolish and construct a new road by next Wednesday.
Well,
All right, all right. Next,
much
next. All right.
May it please your lordship. The petitioner is agreed by the impugned order annexure 11 page 36, whereby my prayer for restoration of my municipal holding number was rejected. Your lordship, the father of the petitioner,
Notice has to go. Yes, heard Mr. B. Pushilal, Learned Counsel appearing for the writ petitioner, assailing the order dated 7/7/2023, issued by the. No, what is issuing, assailing the order dated 11/7/2023. Where is the impugned order?
annexure 12, your lordship, 38, 11/7/2020. Page 38.
11/7/2023, issued by the chairman of the Tezpur Municipal Board. That is the respondent number.
Three.
Chairman is not a party.
Yes, your lordship, represented by the chairman. Respondent number 3, your lordship.
By the Tezpur Municipal Board. That is the respondent number 3. Rejecting the prayer made by the petitioner for restoration. Restoration of your mutation.
Mutation, your lordship.
The instant writ petition has been filed. Mr. Pushilal submits that the impugned order is vitiated by complete non-application of mine. First of all, Mrs. Sharma and government advocate Assam placed for some time to obtain instruction in the matter. And in 6 weeks, since Ms. Sharma has appeared and accepted notice. Correspondent numbers 1 and 2, no formal notice is required to send to the said respondent. Extra copy of the writ petition be furnished to Ms. Sharma within a week from today, so as to enable her to obtain instruction. Petitioner to take steps for service of notice upon respondent numbers 3 and 4 by register post to the.
Obliged, your lordship.
May it please your lordship. Lordship, this matter is relating to ex gratia lordship.
Will issue notice at this stage. Third, Mr. A. Islam, yes, and a counsel for the petitioner. The matter pertains to claim of ex gratia compensation. Issue notice of motion returnable in 6 weeks. Since Ms. G. Hazilka Learned SC Revenue and Disaster Management Department Assam has appeared and accepted notice on behalf of respondent number 1. The B. Gobel and SC Finance for respondent number 2 and Ms. S. Sharma and G. Assam for respondent numbers 3 to 6. Service of notice is completed. This case, extra copies will be furnished to the Learned Department. Council.
Meanwhile, he may approach the deputy commissioner with the next of kin which he has not placed before the Supreme Court.
So to enable them to obtain instruction and file affidavit if so advised. The petitioner is also granted liberty to approach the
Deputy Commissioner of Dhubri.
Deputy Commissioner Dhubri, District Commissioner Dhubri, with the next of kin certificate for processing his claim if so advised.
Lordship.
May I please, your lordship? My lord, the petitioner is a government employee work in a Chief Judicial Magistrate Court. He stood a guarantor of a loan of the respondent number 6. And the respondent number 6 has not paid the loan. Therefore, a notice was issued to the Deputy Commissioner as well as to CJM to deduct some sum from its salary. We have silenced that order, my lord. That
Where is that order?
page 12.
Yes. How much is the amount? Loan amount?
Amount taken was 5,20,000.
And who is the loanee here?
Respondent number 6, my lord.
So what has happened? Your salary has been stopped totally.
No, not yet stopped. My submission is this. The salary cannot be stopped or unless it is a lawful decree from the competent court. The branch manager cannot direct the officer to stop the salary or cut the salary. It is the execution of the decree, the salary can be stopped. Therefore, this notice issued by the bank authority is absolutely illegal. And moreover, along with the notice, they send a statement of account. Your lordship can return to page 18.
You are appearing for whom?
I am for the bank, your lordship, 4 and 5, respondent number 4 and 5, your lordship.
What do you have to say?
Sir, I have to obtain instruction from the bank, your lordship, as my senior Mr. Sharma is unwell today, your lordship. So the matter may be passed over for the day, your lordship. The matter may be listed for tomorrow, day after tomorrow, whatever your lordship may deem fit and proper, your lordship.
We'll have it on Friday, then let us see what is his instruction.
Yes, lordship. Till that matter, the notice may be stayed.
No, what till then? For 4-5 days, we'll pass an order on Friday. Heard Mr. A.C. Sharma, and Senior Counsel appearing for the writ petitioner, who submits that the impugned order dated 12/9/2023 is completely illegal insofar as the bank cannot directly issue instructions to the district administration to deduct or stop the salary of the petitioner. Mr.
P. Agarwal.
P. Agarwal, Learned Counsel appearing for respondent numbers 4 and 5. 6, posting of this matter again on 29th of September 2023, so as to enable him to obtain preliminary instruction and respond in the matter. Full stop. Similar stand of Ms. S. Sharma, Learned G. Assam, appearing for the respondent number
1, 2, and 3.
1, 2, and 3. So one extra copy each be furnished to the Learned Department Council. You see, the point is what Mr. Sharma is saying, that you have to show which authority, which provision of law permits that. Otherwise, this notice is going on Friday. We'll set it aside. Show us a judgment or an authority which permits it. Otherwise, this goes, or you can withdraw the notice with liberty to initiate appropriate proceeding. You cannot unilaterally start enforcing it. It has to be under some statute. That I agree with him. So I'm giving you time only to verify, otherwise this notice is going next day. Friday we'll set it aside.
Much obliged.
Matter item 6.
That's the motion.
Matter relates to my lord, detention of my goods.
Subject to my lord submission of bank guarantee, adequate bank guarantee, the goods can be released otherwise, seized goods.
So what, we can dispose of the writ petition?
I think, my lord, because otherwise, also, my lord, this is hit by subsection 3 of section 129, my lord. And this is mandatory, my lord. And Madras High Court also held, my lord, on that ground itself, it was set aside, my lord, seizure and all.
Let me just have a recapitulation of the facts.
My lord may kindly come to impugned order that your lordship will find at page 60, my lord.
Yes.
And it's is summary of order issued under section 129 subsection 3, and date is very important.
Page
60, my lord, 60.
Yes. Right.
Summary of order issued under section 129 subsection 3, and date of order is, my lord, 29/8/2023. Lord, this is very important, my lord. My goods have been detained on 3rd of August, my lord, and the order passed on 29 August, your lordship. Before that, Soko's notice was issued, that your lordship will find at page.
So, Mr. Goel, just a minute.
My-
Just please take your seat. I want to have a look at. What is this? Seized tires? There were tires also seized.
My lord, homemade BD and tire. Tire against my lord BD, they have imposed tax amounting to rupees 5,26,813, and against tire, my lord, 70,070. So far as
Against BD, what is the tax?
tax is 5,26,813.
13.
813.
And tire?
Tire say 70,000, man.
So what is the total amount?
Total amount, so far as BD is concerned, my lord,
No,
petitioner
no,
one,
What-
total amount of my lord.
So it's 5,96,830.
My
Now these goods have been seized
seized, my lord,
and the final order has also been passed.
passed.
This order
So
is
far-
challenged here.
Here.
There's no provision for appeal.
My lord, because this order has been passed, my lord, in utter violation of subsection 3 of section 129. It says, my lord, Soko's notice is required to be issued within 7 days from the date of detention. And after
No, no, Mr. Goel, what I'm asking is this order not appealable?
I think, my lord, appealable if you actually say.
Then why
But
don't you
since
file
it
an
has
appeal?
been, because my lord,
It can't be that if the order is bad, then we'll file writ petition. If it is good, then we'll file appeal. That can't be the style.
and so far appellate tribunal is concerned, notification has been issued, my lord. And my lord, it is yet to be functional under section 109, your lordship. Under section 109, my lord, there is a provision of appellate tribunal. They have issued notification of, I think, on this month only, but it is yet to be functional.
All right, so for now, we can consider his interim relief and he'll furnish bank guarantee and he'll be released.
Tires and all, my lord, they are not perishable goods. That is-
What will you do with the tire? Bank guarantee is more liquid.
No.
Yes. And on the returnable date, you inform us if the appellate tribunal is functional.
This is my,
And then we'll consider.
Yeah.
Right?
because of that reason I have filed.
Hmm?
Because the appellate tribunal is not functional, my lord, that's why.
Acha. Take down. Heard Mr. A. Goel, Leonard Counsel appearing for the writ petitioner. Also heard Mr. B. Gogoi, Leonard, SC Finance and Taxation Department, Assam, appearing for the official respondents. The writ petitioners have approached this court by filing the instant writ petition, entirely assailing the notice issued by the respond number 3 bearing number MOV-07 dated 17/8/2023, as well as the subsequent summary order It's called a summary order. is it?
Summary order.
Summary
Under
order
section-
dated 29/8/2023. Issued under section 129(3) of the GST Act 2017, inter alia contending that by the impugned order, a time barred claim has been revived by the authorities without
Notice and order has been passed under, which is time barred under section 3.
by issuing the impugned notice and the order, a matter which was time barred has been dealt with by the authorities. Full stop. It is also the prayer of the petitioners that during pendency of this writ petition, the seized BDs, homemade BDs, within quotes BDs, worth rupees 5,26,813, and the tires worth rupees 70,000 seized by the authorities be released, for which the petitioners are willing to issue bank guarantees from recognized nationalized banks. Taking note of the submission of the learned counsel for the petitioner, this court had passed order dated 18/9/2023 requiring the learned SC Finance to obtain instruction in the matter. Today, when the writ petition is called up, Mr. Gogoi submits an instruction that the goods can be released if adequate bank guarantee is furnished by the writ petitioner. First up, the learned departmental counsel has however questioned the maintainability of the writ petition by contending that the order impugned in this proceeding is appealable. Full stop. Responding to the above, Mr. Goel submits that the appellate tribunal is yet to be constituted, as a result of which the petitioner had no alternative but to approach this court by filing this writ petition. Be that as it may, in view of the grounds taken in the writ petition, this matter, in the opinion of this court, would call for deeper examination. As such, issue notice of motion returnable in 8 weeks. Since Mr. Gogoi has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned department counsel within a week from today, so as to enable him to obtain instruction and file affidavit. First up, heard on the prayer of interim relief, having regard to the facts and circumstances of the case, and as agreed to by the learned department counsel, it is hereby ordered as an interim measure that the seized articles, as noted above, be released in favor of the petitioner number 1.
1 and 2.
1 and 2.
What-
Either 1 or 2. Who?
One, he is the owner of BD and 2 is transporter. So far as tire part is concerned, transporter will be.
In favor of the respective owners, within bracket, owner of BDs is petitioner number 1 and owner of tire is petitioner number
He's
2.
transporter, he's not owner of tire. He's transporter, my lord. Petition number 2 is transporter.
And then you, within bracket, we strike it out. To the respective owners on furnishing adequate bank guarantee corresponding to the value of the goods as mentioned above.
Tax, my lord, tax
Uh,
amount, because they are
What is the tax amount?
5,26,813.
Corresponding to the value of the tax amount involved in this proceeding. Full stop. The goods be released within a week from the date of receipt of bank guarantees. Full stop. Insofar as the question of maintainability of the writ petition is concerned, the same will be gone into at the stage of admission hearing. The learned departmental counsel to therefore obtain instruction and appraise this court as to whether the appellate tribunal in the meantime has become functional.
Deeply obliged.
For admission, I can make it.
May it please your lordship.
Yes.
My lord, this matter pertains to certain measures taken under the Disaster Management Act and the direction issued under that act by the district authorities have not been complied with as yet, and the danger looms large on me. And therefore, I am before this honorable court The matter is otherwise ready. And it needs to disposal since the necessary such that it cannot brook delay. Therefore,
One second, Mr. Just one second. Please take this. Who is appearing for response number 7?
I'm appearing for.
Just a minute, let him finish. Yes. Yes.
the Lordship may also like to peruse the order of this honorable court by the collateral bench dated 24th of July 2023. The Disaster Management Authority has been writing, insisting, and therefore that they, on the basis of the submissions of the Disaster Management Authority, this honorable court noted. Then I will come to the facts. 24/7/2023. Paragraph 2. Should I place it, my lord?
Paragraph 2 of?
2 of the order dated 24/7.
Yes, please.
Yes. We can skip the first para.
Yes.
Second para. In course of the proceedings today, the learned government advocate has produced a copy of communication bearing number such and such, dated 21/7/2023, by the Additional Deputy Commissioner and CEO, District Disaster Management Authority, Kamrup Metropolitan, Guwahati, addressed to the respondent number 7 to take precautionary measures within 7 days, failing which the respondent number 7 is forewarned of further legal action against him under the Disaster Management Act. The requirement being, number 1, construction of RCC retaining wall in the lower part of the plot. 2, series of boulder masonry wall with RCC post along the cut portion of the hill. 3, all the earth exposed area to be covered by geotextile mat and vetiver plantation. Needless to say that the respondent number 2 shall pursue his said communication 21/7/2023 and bring it to its logical conclusion. It is also came to the notice of the court that one of the issues which may arise for determination of the writ petition is that the respondent number 7 is in breach of deed of agreement dated 2/2/2020 Annex 6. Therefore, whether the breach of contract can be a subject matter of adjudication of a writ petition shall be addressed by the learned senior counsel or the petitioner in the next date of hearing.
The breach of contract with whom?
Breach of contract with me and the respondent number 7. The court means to say.
You are the original owner of the land.
I am the I am the owner of my plot.
Hmm.
He has cut the land of the hill of his plot. It is by my side.
Right.
It is by my side. So when overnight he has removed the art, it has become so vulnerable that now the whole strip of land might come down immediately. And then my house will also go along with, and not only me, the other people who are there in the downhill shall also suffer damage both in property as well as in life.
Right. No,
Therefore-
I'm asking, what is this agreement?
Agreement, Lordship will see, it is not an agreement in my responsible submission. It is rather a kind of undertaking given by him. In a form of an agreement, he says, kindly see that 6, Annex 6, page 37. When we insisted, we objected that you cannot do it like this, it is posing danger. Then he came up and I have narrated the entire facts. There I have mentioned about this agreement at page 37, Annex 6. Got it, Malad?
Yes.
Now, this was made on 2nd of February 2020. Says first party between so and so, Agarwal is the first party. I am the second party. This is BC Bora, so and so, second party. Now, next 38. And whereas the first party is the absolute owner of plot of land measuring 3 kathas covered by dag number so and so, pata number so and so, village so and so, moja so and so. And whereas this second party is the absolute owner of land and building of GMC house number so and so, holding number so and so, situated at village so and so, 6 Mile, Moja, Beltola in the district of Kamrup, Assam. And whereas, kindly see, the first party intends to construct of a retaining side guard wall on the left side of the plot of first party and on the right side of the second party. And as such, both the parties have entered into this agreement under the terms and conditions as specified described herein below.
So insofar as the question framed by the learned single judge in paragraph number 4, if the matter is decided by this court, it will be held that this cannot be implemented. These bilateral agreements cannot be implemented.
Here. And my submission is,
There is no doubt, element of doubt about it.
yes,
But yes, if you have if your client entertains a legitimate apprehension
yes,
that the hill cutting will be disastrous for his property and the properties of others, it will be for the disaster management authority to
take the call. They have taken the call.
So what is?
There is a joint verification with the forest, revenue, and soil conservation. All have given a report that it is very, very dangerous. And therefore,
Where is the report? Report dated?
page 54, Lordship may turn 2.
54 of your writ petition.
Yes. Here, on the basis of this order was issued by the authority. Page 55, it starts. This was issued to the response number 7 regarding earth cutting on hill area. I am placing it, my lord. With reference to the subject cited above and as per the report received from the divisional officer, South Bank Soil Conservation, it is observed that no requisite precautionary measures were taken during cutting of hill. Hence, now it has become very condition and prone to landslide and also posing threat to the people living in and around the area. Therefore, you are asked to take all the following necessary protective measures as suggested by the Divisional Forest South Bank Soil Conservation Division in order to stabilize the plot of land immediately before monsoon session and submit the action taken report to this, and otherwise action will be taken as per Disaster Management Act
No,
2005.
that's fine. I'm saying, has this court ordered any inquiry or any report?
No, they did on their own. There is a direction from the Disaster Management Authority that you carry out inspection, go to it, see how it was posed. Then all these.
Right.
they have
Who is
said-
appearing for the Disaster Management Authority?
This was repeated thereby. And ultimately,
Yes,
So in this matter, one instruction has been received from the disaster management manual, dated 29/8/2023, which inter alia stated that with reference to the subject cited, I have
question.
to forward herewith the detailed reply of Dilka Sagarwala against notice issued on 21st of August 2023 from this same. As per reply of it, stop the he has stopped the cutting of the art in the year 1919 itself and have not resumed any sort of construction activity. Moreover, he has also requested not to take any coercive action against him as the case is still subject to the final disposal of case of 12th of September 2020. This is.
He has stopped hill cutting in 1990.
Yes,
Yes, well, this report.
when all people there, they protested, police, when they found that it is in very dangerous situation, further cutting will make havoc in the area. There was no, but
So
which every rain, my lord, they are landslides recently.
So today there is no hill cutting.
Today there is no hill cutting, but he is to undertake these corrective measures. If he has failed to do it, then it is for the authority to do it under the law. They cannot leave it in that state.
What do you say on that? Corrective measures?
That is not reflected in the instruction manual. I will take instruction.
And let him come, let the ADC come and tell us how many times will the matter be listed? Why it is not?
I will have the instruction.
They are getting enough time.
The corrective measures will ask them to enforce it. You have not challenged this order.
No.
That is not on basis of the complaint.
Well, whatever, you have not challenged the order.
There is some verification report is there. For verification, report is journal that has been done by on their behest, on the behest of the concerned authority by the police officers. Here, I have entered into an agreement, both mutually, and he has allowed me to.
Agreement has no value.
No
These
value.
are these bilateral agreements, even if he did not raise, these are matters which have a public element of public threat. So even if he today agrees not to continue with the proceeding, even then we'll keep it alive.
Exactly.
It is not about his consent and your consent. There is no question of taking note of any private agreement here. The question is, today, we don't know what is the extent. Tomorrow, if there is a disaster, who's going to take responsibility for this? So the district disaster management authority will have to clarify. So they will have to file an affidavit by next week, proposing what corrective measures, if any, are required. I heard Mr. K.K. Mohanty, Learned Senior Counsel, listed by Ms. A. Begum, Learned Counsel appearing for the writ petitioner. Also heard Ms. M. Burman, Learned Government Advocate Assam. Who is appearing for respond number 1? Ms. G. Hazarika, Learned SC Revenue Department Assam for respond number 1. Ms. M. Burman, Learned Junior Government Advocate Assam appearing for respond numbers 2 and 3. Ms. R.S. Deori appearing for respond number 4. Mr. R. Gogoi, Learned Standing Council Forest Department Assam for respond number 5. Ms. Burman will be 2, 3 and 6. R.S. Devi for respond number 5, R.R. Gogoi for respond number 5, and Mr. D.K. Das, Learned Counsel appearing for the respond number 7. First up, the central issue involved in this writ petition is pertaining to the impending threat of heavy landslides during the rainy season due to apparent hill cutting by the respond number 7. First up, although the hill cutting has reportedly been stopped since many years, yet the petitioner apprehends that at some point of time, due to heavy rains, the hill slope might give in, thereby triggering of heavy landslide, which would not only affect the petitioner, but also several other households which were existing down the hills. So Mr. Mohanty's basic contention is that although the hill cutting has stopped, yet the remedial measures earlier suggested by the disaster management authorities are yet to be implemented. Full stop.
My lord, Lordship may also note in my additional affidavit I have brought in on 26/6/2023 last, when there was heavy rain, severe landslide took place. I have given.
Mr. Mohanty has also invited the attention of this court to the statements made in additional affidavit dated
My lord, 23rd of June 2023.
23/6/2023 filed by the petitioner to contend that during the heavy rains that took place in the season,
In the month of June
in the month of June,
twenty
there
twenty.
was heavy landslide in that area, which had posed serious threat to the life and properties of several persons living in that vicinity. First up, Ms. M. Burman has produced a copy of the written instruction dated 29/8/2023. But the instructions do not reflect whether remedial measures as proposed earlier by the departmental authorities have been implemented by the respond number 7, and if not, whether there is a need to do so even at this point of time. First up, situated thus, this matter stands adjourned till 5th of October 2023, so as to enable the District Commissioner / Additional District Commissioner Kamrup Metro to swear a short affidavit clarifying on the said point. The affidavit be brought on record positively on or before 4th October 2023 by serving advance copy upon the learned counsel for all the parties. First up, the court will consider passing a final order in the matter based on the stand taken by the district administration in the aforesaid affidavit, after hearing the arguments of all the contesting parties.
My lord, regarding the date, my lord, I have difficulties on that. Either it may be on 4th or on 9th, 10th, my lord.
10th.
10th.
Affidavit will file with. Yes.
I am appealing for the respondent, your lordship. I have received parawise comments, your lordship.
None appears for the petitioner when the matter is called up. Ms. R.M. Dekal, Standing Council GST Authority submits that she has received instruction.
But it is not GST, your lordship, custom and DRI.
Custom and
DRI.
authorities who submit that she has received instructions and therefore be permitted 4 weeks time to place the same and record in the form of an affidavit. Since the prayer is not opposed, same stands allowed. Let the matter be listed again after the counter affidavit is filed by the respondents.
Item 24.
Yes, 24, what is the matter?
Your lordship, the matter may be adjourned for the day.
Adjourned for the day.
Yes,
Why?
The learned counsel, Mr. M. A. Islam is not present, your lordship. He had to leave home for some emergency.
It is submitted at the bar that the counsel for the petitioner, Mr. M. A. Islam, is unwell and therefore has not been able to come to court today. On such ground, a prayer has been made to post this matter again after 2 weeks. The prayer is not opposed by learned Government Advocate Assam appearing for the state. As such, this matter stands adjourned for 2 weeks.
Item 25.
May it please your lordship. Lordship, this matter relates to non-grant of educational loan to the petitioner, who is a poor meritorious student, your lordship. He hails from a tea garden community in Silchar area and hails from MOBC category. Your lordship,
Educational loan, this is a 2022 matter.
lordship,
What has happened now?
he is continuing his studies, but there is an ultimatum from the institute that if he does not deposit the fees, he said that my case is pending before the court and therefore they are allowing him. He is about to, course is going to be completed, your lordship. Now, the only ground they are saying is
What
that
is the course he is pursuing?
2 years diploma in pharmacy,
2 years diploma in,
pharmacy D-Pharm,
from which institution?
Shifa Pharmacy Institute at Silchar under Srimanta Shankardev Health University. It is one of the institute affiliated.
How much, what is the educational loan he was?
2,84,000, the amount that is required for the course, your lordship. 84,000.
Which bank is this?
This bank is the Punjab National Bank, your lordship.
So, why you have not given him the loan?
He is not eligible under the relevant scheme. Malad. That is, it's as simple as that. Malad. We have filed the relevant circular. We have given there are set guidelines. Malad. He has to come within those parameters. Is he does not my lord, fall. And basically, my lord, the loan is given to students who come from a poor background, but they are eligible and they qualify from a common entrance test. In this case, my lord, there is no my lord, such entrance test, and my lord, there is nothing to show that he came through any such common entrance test. That is, and there are two heads. One is the common entrance test part. The other is on the basis of the marks in the last qualifying exam. So that he's not claiming. He's claiming that there is a selection common entrance test. But our stand is that there was no such common entrance.
Where is the circular?
Well, that circular, my lords, it is at page 56, my lord. My additional affidavit.
56.
Yes. And the relevant part is at page 57, the scheme.
So this loan to the students are given as per some scheme.
Some scheme.
Scheme floated by?
Schemes floated by all the banks. Basically, what has happened is that the under the RBI guidelines and the Indian Banks Association has a model scheme. The banks are given the liberty to frame their own schemes, following largely with minor modifications, because each bank has its own board, so it has to frame those guidelines. So we have taken a considered decision in this case that he is not an eligible person. Because
why is he not eligible?
No, lordship will come to page 57, this part, the eligibility criteria. This is the eligibility criteria, my lords. So, my lords, if I may read 2B, my lords. 2B should have secured admission to a higher education course in recognized institutions of India through entrance test or merit-based selection process after completion of HSC. However, for admission to some of the postgraduate courses where admission is based on the work experience only, then criteria of selection based on entrance test or selection purely based on marks obtained in last qualifying examination shall not be applicable. Now, see, my lords. While considering the eligibility, where the student has obtained admission in eligible course through merit-based selection process, he or she could be considered meritorious. Generally, admission to professional and technical courses is through common entrance tests, and those who get admission through this process be considered meritorious. Common entrance test, we take a common entrance test for example, the CUET or the NEET or the CAT or CLAT type of courses. This is not a common entrance test. This is an entrance. This is a selection process of a local institute at a local level. Lordship will see the page 17 of the writ petition, what kind of test has been, because it is inclusive of the marks and his last performance. That is basically the case. Page 17.
So, Mr. Laskar,
Lordship.
what is the principle? We can't just direct the bank to give loan. Only thing is if you can show that there is a discrimination meted out to the petitioner.
If
That is
otherwise,
the only ground where Article 14 will come in.
Lordship. If I am otherwise eligible under this scheme, your lordship, I may be considered. This is my case. Now, this is a scheme where he is only pressing on the point through common entrance test. Now, common entrance test generally is conducted like NEET, all India level, then joint and JEE, CUET, common university entrance test. But there are certain courses like B Pharma, D Pharma, there is no common entrance test as such. Every institute does a merit-based selection process. So this clause itself says that he or she should be considered meritorious. There must be if your lordship kindly takes up page number 57, should have secured admission to a higher education course.
So according to you, you come under which clause of this?
Clause B itself, your lordship, page 57. Through entrance test or through merit-based selection process, both the processes are there. I have participated through a merit-based selection process. Page 17 is the answer, is the result sheet of the interview that was conducted by the institute at its own level, your lordship. And I was. It is not that only through common entrance. Now, if there is no common entrance test as such, your lordship, one cannot give it is not a medical course or it is not an engineering course. And in the
meantime, a recognized institution.
Recognized institute. That is, they are also not. This is a recognized institute.
Disputing, but we are saying, if he is pressing on 2B, if eligibility is considered on the basis of 2B alone, not every candidate, every student from particular background will be eligible. Not that will lead to no end of loans. So we have to go through some eligibility process. We take that if anyone comes from a common entrance test or from a larger, taking a broad view of the matter, so it has to be a competitive process. Lordship will see page 17.
No, why is it necessary for a common entrance test?
Because that is the scheme. That is the scheme that either he has to challenge the scheme that this is arbitrary or discriminatory. He has not done that.
Scheme is not under challenge.
No. He says that I'm eligible under two B, but if we take two B literally, my lords, then every student will, my lords, will be eligible for loan. Then we will be, my lords, under.
So have you
Quite
shown anybody else who is similarly situated who has
Yes,
been
yes,
given loan?
Lordship,
Who?
it is there, I'll produce your lordship.
No, I will not take papers like this. You have to file affidavit. You can't give papers like this.
No,
Has anybody else doing the same course been
Have-
given
have-
by given loan by the bank?
not this bank, but one is by Canara Bank, one is by the State Bank of India.
Same course?
Same course, same institutes, his friends, your lordship.
Then why haven't you brought this by filing affidavit?
Now, recently I have brought it, your lordship, and secondly, your lordship, this scheme
So
does,
that this I will not consider in your favor unless you file affidavit.
time is also running short, your lordship.
Can't help it.
And otherwise also, your lordship, there are two options. One is that there must be a common entrance test. Yes, there was no common entrance test throughout the state, but there is a merit-based selection process to which they are.
Mr. Laskar, otherwise your petition will be dismissed. If you want to bring it on record by week, I
Lordship,
can give you that time.
lordship,
Otherwise, we are not sitting here to decide who should get loan and who should not.
lordship.
We will only see whether the banks have acted in an arbitrary and discriminatory manner. That's all.
Next Monday, your lordship, I'll file.
Next Monday, I am not coming to court.
Sorry, your lordship.
Yes,
Solicitor,
heard Mr. Laskar, learned counsel for the writ petition, also heard Mr. A. Ganguly, learned counsel appearing to the respondent. On the request of Mr. Laskar, this matter is directed to be posted again on 5th of October 2023, so as to enable the petitioner to file an additional affidavit by serving advance copy upon the respondent's counsel.
I'm declared.
Please do remember the principle which we will follow. The principle is not whether he should be given loan or not.
Lordship.
We are not concerned. This is bank's money, bank will decide. The principle is whether this violates the constitutional right of the or statutory right of the petitioner. That's all. If we can show that some other bank, and if some other bank has been done, then will it be binding on them?
Each bank has its own scheme, which minimum
Same
modifications.
It's the same scheme.
Same.
No, it cannot be. Our scheme is different. How can it be? Manoj? He has to place the scheme then on record also, along with, let him show.
Then you have to approach that bank.
No, because there is a requirement that he should contact his nearest bank. Now, his nearest bank in the tea garden area, this bank is situated, your lordship. Now, he cannot go and, because they have also that his home should be nearby. The nearest bank is this Canara.
Who has made this requirement nearest bank?
That is there, your lordship.
All right, you
Maybe
file. your
SBI is Manoj everywhere, so it cannot be.
No, but
But
nearest
there is no scheme. State Bank of India has no such scheme.
State Bank of India has also.
You have not applied
I
there.
have not applied since this was nearest bank. They have initially said that you apply, you will get it. After applying, they are showing that you give collateral security. But as per the rule, your lordship, up to 7 lakhs, there is no requirement of collateral security. So they said they denied. Thereafter, I have challenged. Now they are saying that I am not eligible under certain other conditions. To initiate their say is
But
that
merely by saying that he doesn't require, may fulfill the requirement of scheme will not be enough. You have to tell us why you will not give him the loan. He's
But
a-
we have explained that in the affidavit. He does not, he is not eligible under the scheme. Manoj. That is what.
That's
we
the
have
only
said.
reason.
Yes, Manoj, that is because we
If
go by
the
the.
court
guidelines.
holds that this is an erroneous view, that's the end of the matter.
Yes, Manoj, of course. All right, subject to judicial review.
next,
Yes.
I am declared.
Lordship, in this case, we have filed our affidavit in reply. There are some defective, we have rectified the defective lordship on, it was filed on, ultimately it was filed on 23rd. Lordship, let it be, come on record also. Next week. So we have typed out some 10 pages, Lordship.
My lords, liberty was granted to them to file their counter affidavit. They've served us a copy. Your lordships may.
Counter evidence, he is the petitioner.
Yeah,
I have
additional
filed my
affidavit,
reply,
sorry.
Lordship.
Huh?
I filed my reply, Lordship.
Additional affidavit.
That has not come on the record.
When did you file it?
Lordship, we have submitted it on 19, Lordship, ultimately it was filed on 23rd, 23/8, Lordship. There are some defective, we have typed out.
23/8.
23/8. So, Lordship, sorry, Lordship, it was filed on, on 23rd, Lordship, 23/9, Lordship.
Oh, whether it's 8 or 9, you can't,
23/9, Lordship.
23/9 is a Saturday.
Saturday, on Friday, Lordship. Last Friday, no?
Friday is not 23/9, Mr. Das. What is the matter with you?
No, Lordship.
You can't even give this simple information to the court.
Lordship, 22/9/2022, 22/9, Lordship. Date of receiving.
Yes.
My lords, in the averments they have sought to bring on record, they're all factual. They have approached this honorable court in a writ jurisdiction claiming money by way of a summary request. My lords,
So therefore, the affidavit should not be brought on record.
no, my lords, I'm saying that it will not help the course of the proceeding. The observation on the last date of hearing was,
He's saying get the affidavit on record.
my lords.
Are you opposing it?
No, I'm not opposing.
If you are opposing, you are
I'm not
entitled to
opposing. I'm
argue.
not opposing.
So then what happens? Today, can the matter be heard?
Lordship, let the affidavit be in the record, Lordship, because they have made an objection, Lordship, we have
You
not
have received a
submitted,
copy.
I've received the copy.
they have made an objection, Lordship, that we have not submitted the engagement certificates of the passed out candidates. In our.
What is the matter about really?
Lordship, we have provided, Lordship, training, Lordship, skill training to, Lordship, some courses in batches as per contract agreement, Lordship. And the third installment, they have withheld.
They means who? Who has withheld?
The Assam Skill Development Mission, Lordship.
You are appearing for them.
For the respondent number 2 months.
Lordship, let
Why,
the-
why it has been withheld?
My lords, the last installment was subject to a verification, which was to be based on certain documents which they were supposed to submit within the period of time also, my lords. I mean, it's a contractual arrangement where after the completion of the training and after the final exams are conducted, they were obliged to place all the candidates, not all, but the candidates within 3 months thereafter. That fact had to be established by them by submission of certain documents as per the contract, my lords, which they failed to. After that, they approached this honorable court in a writ petition. The writ was decided. The writ was decided in their favor. Liberty was granted for them to approach the ASDM again, which they did, my lords. Subsequently, after they basically put all their documents on record as per the contract in the correct form, we found them ineligible, my lords. The verification failed. For most of the candidates, the requirement was a minimum of 50% of the candidates as trained by them had to be placed, my lords, successfully, which was not done, my lords, and therefore their claim for that third installment is not eligible for payment. That's
So if they give those materials to show that,
they have already.
then why? aren't-
Based on that material, I have conducted the verification.
And you found that?
That the verification duly failed after the an independent verification was done by us, my lords, and therefore we have denied that claim.
Lordship, they have done this verification in 2022-23. The passed out candidates were, Lordship, in 2019. They may not be engaged in the same organization, Lordship. They may have shifted to some other.
Alright, we'll get the affidavit, but the writ petition is not maintainable. When do you want it? Mr. Das, how can we decide on these things?
Lordship, we also brought on record, Lordship, the engagement certificate of the passed out candidates. Lordship,
You're
we
not
can-
going to hear
In any case, there's also an arbitration.
You have to choose between civil court and arbitration. Come prepared on the next day. You may not get another chance to come prepared on that. Mr. S.K. Das, counsel for the writ petitioner, submits that the rejoinder affidavit filed on behalf of his client on 22/9/2023 is not on record. Submitting that the rejoinder would have a vital bearing in the outcome of this case. Mr. Das seeks posting of this matter again after 2 weeks by taking the affidavit with the record of this case. Mr.
K. Khanna, my lord.
A. Khanna and counsel appearing for the
Respondent number 2, my lords.
2 is present. And 6 posting of this matter again on. Who's a non-miscellaneous?
My lords, any date.
Again on. Should it be after vacation?
After the vacation.
Yes. Again on 9th of November 2093 as a fixed item. In view of the prayer made at the bar, let this matter be listed again on 9/11/2023. 9/11 is a good date? or you want to-
9/11.
No problem with 9/11. 9/11/2023 by taking the rejoinder affidavit with the record. of
Great.
this case. Yes.
May it pleases your lordship, my lord, in this matter relates to the election to Atkelia Namghar. There was an order that an inquiry be held as regards the election by the Commissioner Upper Assam Division, my lord. But on the last occasion, there was the information that that post has been done away with. Therefore, the respondents were directed to apprise the court, my lord.
I have spoken to the Deputy Commissioner Golaghat. And he says it's a fact that the post of divisional commissioners are abolished. Now it has been taken care of by the Principal Secretary, GAD. So that inquiry was not conducted possibly by the.
No, inquiry,
Which is the order by which inquiry was?
in the IA, your lordship will find, this is passed in IA 3292 and the order is dated 21/23. I think a copy of the order was kept, is kept in the main file. Your lordship may file that.
So IA has been disposed of.
Disposed of by this order. Actually, what happened, my lord, initially, because we had, there was orders of this court that elections be held. Accordingly, elections were held. Thereafter, the DC district magistrate did not allow us to take charge, my lord. That is the time when we had approached this court. Then there was a direction that the DC may inquire into the election, but it is the DC's order that we had challenged. Therefore, we filed an IA and accordingly it was modified. That order, your lordship will find in the IA, which is dated 21/23. Modified to the extent that the inquiry now will be held by the Commissioner, Upper Assam Division, Jorhat. Has your lordship got that order?
Last page, huh?
So now who is to hold the inquiry?
It is the works of the divisional commissioners are looked after by GAD, Principal Secretary. General
So
Administrative.
then let him hold the inquiry as per the court order and submit a report. How long will it take?
Principal Secretary Koriba.
Is three,
How long will it take?
maybe 4 weeks.
Yes, Mr. Goswami,
Well,
4 weeks, all right. Heard
but
Mr.
only thing, all the documents be handed over to them and we may be allowed to also, because this was there. He has to hear us, my lord. So whoever is doing the inquiry, let him do all these.
You submit your documents.
Notice to all the parties.
Notice to all parties.
All right, I heard Mr. K. Goswami, Learned Senior Counsel, assisted by Mr. S. Sandile, Learned Counsel, appearing for the writ petitioner. Also heard Mr. B.J. Talukdar, Learned Senior Counsel, assisted by Mr. S. K. P.K. Medhi, Learned Government Advocate Assam, appearing for the official respondent. Mr. M. Nath, Learned Senior Counsel, appearing for, assisted by Mr. D.J. Kapil, has appeared for respondent number 6 to 16. By inviting the attention of the order dated 21/2023, passed by this court in IA bracket civil bracket close number 3292 of 2022, whereby this court had directed the divisional commissioner to conduct an inquiry on the issue raised by the writ petitioner stroke applicant and thereafter submit a report. Mr. Talukdar submits that the post of divisional commissioners have in the meantime been abolished, and at present it is the principal secretary to the government of Assam General Administration Department who is the authority discharging the functions of divisional commissioners. As such, if the court permits, the inquiry as directed by order dated 21/2023 can now be conducted by the principal secretary to the government of Assam, GAD. The learned counsel for both the contesting parties have submitted that they would have no objection if the order dated 21/2023 is modified to the above extent. In view of the above, the principal secretary to the government of Assam, GAD, is hereby granted 6 weeks time to conduct an inquiry in terms of the earlier order dated 21/2023 passed by this court and thereafter submit a report. The inquiry, then let him take 8 weeks because there will be vacation, 8 weeks time. The aforesaid authority may issue notice to both the rival parties, intimating them the date of appearance before him so as to enable them to submit their versions along with supporting documents. The report be prepared after taking into account the facts and circumstances as well as documents to be produced by all the interested parties, including the contesting parties hearing. The report be presented on the next date fixed. The registry is directed to list this case again on 20th of November, 2023 as a fixed item.
Well, deeply obliged, my lord. And let the proceedings which was there before the commissioner, that also be given to the principal secretary. My lord.
Let him first
Right,
get the
deeply
report.
obliged.
Item 35 and 36.
So it will be, that will not be 8 weeks. It has to go to 28, 28.
May I please your lordship, a matter may be passed on for the time being. My senior index in code number 21 and our matter is going on lordship.
What is the matter?
Regarding cooperative society, but I don't have idea regards
All right,
cooperative society.
but you have to do it before rising, otherwise, yes, time being.
Item 37. 37.
We have received instruction, my lord, in this matter.
None appears for the lead petitioner when the matter is called up, Ms. M. Barman Lanil. You are appearing? She has received instruction, let her file affidavit. Let her file affidavit.
My lord,
You are appearing for?
all the respondents.
Mr. R. Ali Land Council is present for the petitioner. Ms. M. Barman Lanil, G. Assam appearing for all the respondents. Submits that she has received instructions and therefore be permitted 4 weeks time
My
to file affidavit. Prayer allowed. Let the matter be listed again after the puja holidays. In the meantime, affidavit on behalf of the department be placed on record. Huh? Where is the IA? Who are you?
Also, I am one of the guardian and ex-president of the Anganwadi Center.
What is the issue here?
My lord, regarding my lord, the construction of my lord, center, my lord, after erosion by the Brahmotra, it was my lord directed to ship in a
Do you have
particular
any
place.
objection to his treatment?
He may be, my lord.
All right, take down. Heard Mr.
Eti Shorka.
Shirka Land Council appearing for the applicant. This is IA 768 of 2023. Also heard Mr. R. Ali Land Council appearing for the lead petitioner, OP number 1. No, lead petitioner. OP number 1, Ms. M. Burman, Leonard G. Assam is present on behalf of the official opposite parties. This IA has been filed with a prayer to impede the applicant in the connected read petition by full stop. Mr. Sarkar submits that his client is the former president of
Anganwadi Center.
Anganwadi Center.
Yes.
Lost.
Since the controversy involved in this writ petition pertains to shifting of the Anganwadi Center, hence the applicant is interested in the outcome of the proceeding. On such ground, a prayer has been made to impede the applicant as respondent number 5 in the connected writ proceeding. Mr. Ali submits that he would have no objection if the prayer is allowed. In view of the above and after taking note of the submission made by the applicant's counsel, this court is of the opinion that the applicant is required to be heard before the writ petition can be finally disposed of. As such, it is hereby ordered that the applicant, namely so-and-so, be implemented as respondent number 5 in the connected writ petition. Full stop. An amended cost title be filed in this matter within 2 weeks from today. IA stands disposal.
Item 38.
Maybe in this matter, my lord, today we have filed an affidavit in reply to the affidavit filed by the respondent 4, my lord. It is not on record, my lord. Kindly.
You have received?
I have received.
All right. Heard Mr.
K. Uddin.
K. Uddin, council appearing for the writ petitioner who submits that a rejoinder affidavit on behalf of the petitioner has been filed today. Mr. Mr. M. H. Lashkar, council appearing for the respondent number Four. And Upon Mr. S.K. Talukdar, learned SC Cooperation Department, Assam, and Mr. M.H. Lashkar, learned counsel appearing for the respondent number 4 have confirmed receipt of the copy of the rejoinder affidavit. However, the affidavit is not on record. Office to therefore tag the affidavit with the record of this case and list the matter for admission hearing after 2 weeks.
My lord, the interim order may be extended.
Interim order- Is there any urgency?
No.
Let it go after vacation.
Yes.
Then a date may
After
be
4
fixed.
weeks,
Lordship
interim
may-
order passed earlier to continue. Yes.
Apply.
Item 39.
Yeah, please, your lordship, as for last order, my lord, instruction was called for my lord. As last.
Sanction has been accorded, my lord. It is sent for approval to the government.
I heard Mr. W. Rahman, learned counsel for the petitioner. I also heard Ms. M. Burman, learned counsel, learned government advocate Assam, who has produced a copy of the order dated 22/9/2023 to submit that the necessary financial sanction for payment of ex gratia relief to the petitioner has already been issued. And now the matter has gone for
For approval, my lord, to the, to government, my lord. This,
approval of the government. Full stop. In view of the above, let this matter be listed again after 3 weeks, so as to enable the learned government advocate Assam to obtain updated instruction and
It is-
appraise this court as to whether the payment has, in the meantime, be released in favor of the petitioner.
revenue may also have that instruction because.
Ms. P.
revenue-
Hazanika, learned SC Revenue, and Ms.
RM Barua.
R.M. Barua appearing for the Finance Department Assam to also obtain necessary instruction.
May I please, sir?
Yes.
Lordship, in this case, the petitioners are victim of illegal eviction, Lordship. Lordship, on,
Illegal eviction.
yes, Lordship. On 16/2/2023, Lordship, the respondent authority paid eviction in Lachimari area, Lordship, which is a forest area, Lordship. The petitioners are living on their Medipata land in Chitolmari Pathar, Lordship, which is adjacent to the Lachimari area, Lordship. And while they carried out eviction in the Lachimari area, Lordship, the.
So you are occupying Mehdi Patel.
Yes, Lordship.
Then there is already an interim order.
Yes, Lordship.
Then
But we are for compensation, Lordship,
compensation for what?
for demolition, Lordship. They have demolished our residence, Lordship, and agriculture and cattle, etc., Lordship. There is.
Yes, you have got instructions.
My lord, from this is and instruction has been received. It is stated that there is no eviction in the Myadipatta land, my lord.
Then you have to file affidavit.
Yes, my lord.
Heard
Only
Mr.
forest
S. Alok,
areas
learned
are-
counsel for the petitioner. Also heard Ms. M. Burman, learned government advocate Assam, who submits that she has received instruction from the district administration and therefore be granted 4 weeks time to file affidavit. Similar is the stand of Ms. Ms. N. Bordeloi, learned standing counsel Revenue Department Assam, appearing in this case. On the request of learned departmental counsel, this matter stands adjourned for 4 weeks. First, to enable them to file affidavit after serving advance copy upon the petitioner's counsel.
Item 43.
May I please, the Lordships? In this case, Lordships, respondent authority damaged my part of the building that after duly accorded permission and constructed that building while evicting the other buildings, other occupants, they are occupied by the government lands. Suddenly, they have also damaged my part of the building. And that's why I approached this court, Lordships.
Approach for what?
Approach restrain the respondent to not to further damaging my building since it was a part of our building, Patta land, and after due permissions, it was.
There is already an interim order.
Yes, interim order is there.
Instruction has been received, my lord. 4 weeks time.
All right. So and so for the petitioner, so and so, appearing for the state submits that instructions have been received and therefore 4 weeks time be granted for filing affidavit. Similar is the stand of so and so appearing for revenue and forest departments. On the request of learned departmental counsel, this matter stands adjourned for 4 weeks so as to enable them to file affidavit. Interim order passed earlier to continue.
Item
Like,
Please, Your Lordship, in this case, I am appearing on behalf of respondent number 1 to 4, Lordship. I need another 3 weeks time for filing it.
None appears for the petitioner. Mr. R.K. Talukdar, Learned Standing Council, PGCIL, appearing for respondent numbers 1 to 4, 6, further 4 weeks time to obtain instruction and file affidavit.
My lord, in this matter, we have not served extra copies for sending.
Yes,
notices.
I'm
I'm
Barman
appearing
Lada,
5, 6, and
Government Advocate Assam, appearing for the respondent numbers 5, 6, and 7, and
for 5.
Acha. Okay, Miss N. Bordelais, Learned SC Revenue, appearing for respondent number 5, and Miss M. Barman, Learned Government Advocate Assam, appearing for respondent number 6 and 7, have submitted that due to want of extra copies, they could not obtain instruction in the matter. In view of the above, let this petition be listed again after 6 weeks. In the meantime, the petitioners counsel to serve extra copies of the writ petition to the Learned Department Council, so as to enable them to obtain instruction. The respondent number 1 to 4 may also file affidavit in the meantime. Yes.
My lord, in this case, my lord, they issued, my lord, election notification of the cooperative society in question, my lord. But my lord, in the middle, my lord, they changed the, my lord, the procedure, my lord. Violating the, my lord, election notification, my lord. This is the grievance, my lord. My lord, first it was, my lord, page 19. This, my lord, Board of Director was constituted in the year 2017, my lord. It was approved on 26, 2017, my lord. And as, my lord, they failed to hold, my lord, annual general meeting, my lord. This committee was dissolved, my lord, on 18 June 2022, my lord. And thereby, my lord, direction was issued by appointing, my lord, one-man committee, my lord, to hold the, my lord, election, my lord. And thereafter, my lord, election notification was issued as usual, my lord. But in the election notification, my lord, it was provided that,
Who
my
are
lord,
running the affairs of the board now? Of the society now?
Now there is a, my lord, elected board.
Elected body.
My lord.
He's
elected
challenging the election.
body. Yes, yes.
Then
He's
Yeah.
submitting, he's not challenging election. He's saying that election notice was issued on 9/12.
Hmm.
22. 14/12 was the last date for submission of applications.
Hmm.
They did not submit,
Hmm.
but they say that we, the respondent number 7 to 20 who submitted,
Hmm.
they are disqualified under law.
Hmm.
He filed the writ petition
Hmm.
on 19th of December. He did not file with before 14 or on 14. He filed on 19th of December, challenging that our nominations are bad in law.
Hmm.
To that extent, there are judgments of this court saying that the requirement of section 39 is if the board does not calls for a meeting, but wrongly conducts or does not conduct, then the rigors of 39 applies. Dissolution under 39 per se does not disqualify from subsequent participation. If the secretary had called the meeting was conducted, but the quorum was not reached, it does not call for disqualification. There's a division bench judgment of this honorable court on that point. Regardless of the matter, if they choose not to participate in the election, let the nomination date go over, the last date for filing nomination.
So just a minute. The elections were held.
Yes.
New board has come. They are now operating and the election has been given approval. So is he required to challenge the order of approval?
Yes.
Is it under challenge here?
No, he said nomination.
Nomination cannot be done.
my lord, there is a order, my lord, from this, my lord,
And if an approval is granted, is it appealable under 111?
In fact, my lord, pursuant to coming into force of the, my lord, election rules 2019, essentially, if it's an election dispute, my lord, that has to be filed within the election authority, my lord.
not, my lord, may I submit, my lord? I challenge, my lord, entire election process, my lord. And, my lord, earlier occasion, this honorable court provided that, my lord, this election is subject to the outcome of this writ petition, my lord. Because my lord, they are.
Their elections cannot be set aside in this writ petition. You can argue for 2 days.
No, my lord.
You have to challenge their election for improper nomination. There is a provision in the Representation of People's Act. That is the law even in case of a parliamentary election or assembly election.
My lord.
One of the ground for challenging the election is that nomination has been received improperly. But these things can be gone into in an election proceeding, not in a writ petition.
My lord.
Once there is a procedure prescribed by law, you have to go there.
No, my lord, my lord case is little different, lordship may consider, my lord.
Now, after the elections are held, it cannot be interfered.
My lord, here what happened, my lord, election, my lord, it was nomination, my lord, process was okay, my lord. But in the middle, my lord, higher authority, my lord, pushed some, my lord, unauthorized, my lord, candidate in the election process. This is, and I am challenging the order of, my lord, page 33, my lord.
So you want fresh elections to be held?
Yes, my lord.
That is not possible. You have to set aside, get the elections of the earlier members set aside.
So, my lord, my lord, before election, my lord, I filed this writ petition, my
But
lord.
you didn't get an interim order.
No, lord, it was provided that, my lord, insisted for interim order, but it was provided that, my lord, election is subject to the outcome of the writ petition, my lord. Therefore, my lord, they cannot, my lord, harp, my lord, this ground, because, my lord.
The court is saying this. We'll close it by granting you leave to challenge their elections.
Election, my lord, for election purpose, my lord, there is a election authority, my lord, there is a statutory provision, we have to file appeal, my lord, before that, my lord. But here, my lord, they nicely issued notification, it's okay, my lord. But subsequently, my lord, unauthorized person, my lord, higher authority, violating the election notification. My lord. Election is so sacrosanct, my lord, I also admit before your lordship. But they have not maintained, my lord, this.
You go to the authority in the corporation department first. Why should the writ court get into it?
This election, this authority himself, my lord, push this, my lord. He cannot adjudicate this matter, my lord. Lordship kindly will page 33, my lord.
Then let him go to the government. He can file an appeal before the government. You file an appeal before the government. Writ court will not decide these
My lord,
matters.
government, my lord, may be given, my lord, because.
These two writ petitions, why are these two writ
My lord,
petitions?
they are almost actually same, my lord. They have both the case, my lord, they have violated their own, my lord, election notification, my lord. Only, my lord, during the process, my lord, some unauthorized, my lord, invalid candidate, they, my lord, they allowed, my lord, by, my lord, administrative order, my lord. This order is, my lord, lordship page 33. my lord.
Allowed to what? Participate?
Participate in the election, my lord. As per law, my lord.
As
they-
candidates, as candidates.
Yes, my lord. As per law, my lord, they are disqualified, as per statutory provision, my lord. But they made some, my lord, purported, my lord, application and it was allowed, my lord. Page
So this is
33.
the same society.
No, my lord, this is different. One Hailakandi, one
Issue is the same.
Actually, you take down. Then let them prefer an appeal under which provision? 111.
111.
111.
111.
Now, my lord,
Lots of.
1113, my lord, if it is passed by the registrar, it's maintainable before the government, 1113,
1113.
my lord.
So he'll challenge the approval. They will challenge the approval of the proceedings granted by the registrar. By filing, what order will they challenge? They have to challenge something.
Yes,
The elections have been approved.
my lord.
So we'll grant him liberty to challenge the approval order.
Yes, that can be done, but here, my lord, in the writ petition, the order allowing, my lord, the candidates to participate in the election is under challenge. That order is under challenge.
Where is that order?
page 33, my lord. And my lord, this author taken a shelter, my lord, one provision, it is, my lord, palpably, my lord, it is incorrect, my lord. There is no such provision, my lord, under 29(4) of the Cooperative Societies Act 2007 to allow such kind of, my lord, invalid candidate in the election. my lord.
Okay, you take down. I'm passing this order in WBC 8300/2022.
My lord.
This is item number 35. You take down, heard Mr. A.M. Borbia, Learned Counsel appearing for the writ petitioners. I have also heard Mr. S.K. Talukdar, Learned Standing Counsel. Corporation Department, Assam, appearing on.
1, 2, 3, 4, 5, 6, my lord.
Phone numbers 1, 2, 3, 4. 1 to 6.
1 to 6, my lord.
Mr. S. Banik, Learned Council is present on behalf of respond numbers 7 to 20. Full stop. The writ petitioners herein, numbering 12 in total, are the shareholders of Tarapur Samabay Samiti Limited, situated in the district of Kachar. According to the petitioners, ineligible candidates have been allowed to participate in the last election, in the last election of the Samabay Samiti Limited held on, when was it held?
My lord, it was held on 24/12/2022. My lord.
24/12/2022.
22.
On the strength of the order dated
9/12/2022.
9/12/2022, issued by the Additional Register of Cooperative Societies. According to the petitioners, the acceptance of nomination of as many as 14 numbers of shareholders of the society. All of them are elected.
My lord, the election, my friend.
Many of them who have been elected to the 15-member board is illegal and hence had a vitiating effect on the election process itself. The petitioners are also aggrieved by the approval granted to the proceedings of the election stroke AGM, although the order granting approval is not specifically under challenge in the present writ petition. Full stop. Mr. Talukdar submits that the impugned order dated 9/12/2022, as well as the order granting approval to the proceedings of the AGM oblique election are appealable under section 111(3) of the Assam Cooperative Societies Act 2007, and therefore the writ petitioners must be directed to avail alternative remedy as may be permissible under the law.
With one aspect, so far as the approval is concerned, that is by the ARCS, my lord. So that would be applicable for the register. So far as this order is concerned, having been passed by the register, additional register, that is applicable before the government.
Mr. Talukdar has further pointed out that the impugned order dated 9/12/2022, having been issued by the Register of Cooperative Societies. No, this is additional register.
It's saying he exercises the power of register, my lord, in absence of the register, my lord.
Additional Register of Cooperative Societies, who exercises the power of Register of Cooperative Societies. His said order would be appealable before the government.
My lord.
However, according to Mr. Talukdar, the order granting approval to the proceedings of the AGM stroke meeting
Election,
having been AGM stroke election having been passed by the
ARCS, my lord.
ARCS, is an appeal against the said order would lie before the
Register,
of Register of
Cooperative Society,
Cooperative Societies
111 subsection 1.
under section 111(1)
My lord.
of the Act of 2007. Full stop. Next, Mr. S. Banik, Learned Counsel for the private respondents, submits that once the elections have been held and the proceedings have been approved, the only remedy that can be availed by the petitioners is by calling into question the election of the individual members elected to the board. Full stop. Be that as it may, since the petitioners' counsel has also agreed that the issues raised in this writ petition involve several disputed questions of facts which would require a factual inquiry. Hence, by granting liberty to the petitioner to avail appellate remedy as may be permissible under section 111 of the Act of 2007, This writ petition stands disposed of by providing that if an appeal is preferred before the appropriate authority within 2 weeks from today, the same be considered on merit and disposed of by a speaking order within 4 weeks thereafter, after giving an opportunity of being heard to the contesting parties.
My lord, Lordship may be pleased to allow my lord to file one appeal before the government, my lord, and he, because higher authority, my lord, may consider, my lord.
How can it be?
No, it will depend on what is the statute.
Yeah.
We are not, you take a decision. You are the lawyer. If one appeal is maintainable, you file one appeal.
Yes.
We will not give you. What is the other case? Same thing.
Same thing, my lord. Order would be different, my lord.
Order would different. It is impugn order page 55.
What is the name of the society?
My lord, this is.
Other matter?
Hatir Kupa Samabay Samiti Hailakandi, my
My
lord.
lord, Buttercup Samavas Singh.
And the order was,
Order, my lord, passed on, my lord, impugn order passed on, my lord, 14 December 2022, my lord.
14 December 2009. Rest will be same. And then approved. Huh? And he'll be for 7 to 10. You are for 1 to 6.
And my lord, election was held on 25/12/2022. And my lord, election notification was issued, my lord, on 8/12/2022, my lord.
So take these two dates. And in the earlier matter, election notification was issued when? Is it item 35?
Yes.
9/12.
Election notification was issued on 9/12/2022.
9/12, election was held on,
24/12/2022.
so make this change, the same order.
Obliged.
Dispose. Yes.
For order, item 45.
Oblige.
In this case, it was submitted, my lord, that the petitioner, my lord, secretary has been changed, the managing committee has been changed, my lord, the school, my lord. My lord, I have, my lord, received some instructions, but I would like to file an affidavit, one last opportunity, my lord, next time.
Otherwise, my lord, in this matter, nothing remains. My lordship will remember this is with regard to, my lord, allotment of land to the Central Administrative Tribunal for construction of the permanent building, my lord. Government, what did, my lord, 2 plots of lands were there, my lord. First plot was to the school, second plot was allotted to tribunal. The government, my lord, took a decision to swap the land. The second plot of land was given to the school and first plot of land was given to the Central Administrative Tribunal. Now construction is going on, my lord, with substantial, my lord, portion has been completed. Now, their contention is that they objected to that allotment, my lord. Now the school managing committee which objected, that is the petitioner representing, my lord, the school managing committee has changed and they have, they are now satisfied with the plot of land and they have constructed their school also newly. And that is going on. So I don't think, my lord, there is anything remain. My friend wants to file an affidavit, my lord,
That is
it's all right.
That is disputed, my lord, that is disputed.
What is disputed?
Let him file. Let him file. Mr.
But nothing
And
remains.
that's the learning council for the writ petitioner submits that after the writ petitioner submits that after the change in the management of the school, he has received some updated instructions which are required to be brought on record by filing affidavit. Therefore, 4 weeks time be granted for the purpose.
No, my lord, change in the school, I don't, my lord, admit, my lord. I said this is disputed, my lord. Change is disputed.
New committee has filed today one application for.
Including, my lord.
That a copy has not been served on me.
Yes, I'll serve.
Mr. M. Dr. Sorensen submits that he has received some updated instruction which requires to be brought to record. Brought in the record by filing an additional affidavit. Therefore, 4 weeks time is required for the purpose. Full stop. Implement application. will be filed.
Yes, I'm about to file, my lord, today, my lord.
Okay, Mr. We'll pass an order in that IA. You are about to file.
Yes, sir, yes, it's being, yes, it's being filed today.
Then you
my lord.
file it.
Yes, my lord, I'll file.
Mr. H. Das, HK Das, Learned Council for the respond number
8 and 9, my lord.
8 and 9 is present. Can you give the appearance, please?
Yes, yes, my lord. Fine.
If serially give it. to me.
Yes, yes. Diploped. Deep.
Wait, please, Your Lordship. Non-compliance of the order.
Where is the order? Which is the operative part? Let us see.
Operative part, my lord, page 11. Since the municipal board has referred the matter to the respond number 3, i.e. the district commissioner Dhubri seeking his advice in the matter, I am of the view that no practical purpose would be served by keeping this writ petition pending before this court any further. As such, this writ petition is stand disposed of by directing the respond number 2 to examine the grievance of the petitioner and pass appropriate order issue approved direction as may be warranted. In the facts and circumstances of the case, preferably within a.
So
10
no order has been issued.
No, my lord, not yet.
M. Hussain Baki, you write it. Multiple respondents, sir. 8 weeks. Yes. Registered court.
My lord, pendency shall not be filed.
These orders are not passed in contempt.
My lord, obliged.
May I please your lordship? Lordship, the item can be passed over for time being. My senior, Mr. Api Sharma, is in led. The matter can be taken up at 2.
This, what order is it?
My lord, service is complete on all the private respondents, my lord. I am appearing for private respondent number 7 to 12.
Your name, please.
E Deka.
This A. Decca Learned Council is present for the for the petitioners. Mr.
A Das, my lord.
A. Das Learned Council appearing for the
For all the private respondents, 6
for
to
the
12. my lord.
private respondent number 6
6
to
to
12.
12, my
submit
lord.
that, he has entered appearance on behalf of the same respondents. Mr. N.K. Devnath, Learned SC PNRD Assam, and Mr. J. Hendik, Learned Government Advocate Assam are present on behalf of the official respondents. It is submitted at the bar that this matter is ready as regards service office to therefore verify and list this case for admission after 10 days.
May I please the lordship. As per the last order, lordship, the office noted dated 19/9. It is reflected that lordship, no oklatnama was filed in respect to petitioner respondent number 4 and 5. So that's why service has been completed, lordship. Lordship, pursuant to Lozima Court Order 78/2023, it's reflected, lordship, that deemed to serve. 7/8/2023, lordship, Lozima Court Order. And moreover, lordship, the respondent number 4 and 7, lordship, already show cause reply has been submitted. This is on the record, lordship. On the record, lordship. So that's why, lordship, their service has been completed, lordship.
Show cause reply by
The respondent number 4 and 5. That is, lordship, why this is called show cause, I do not understand. Notice has been served, but they have submitted, lordship, show cause reply. It's mark, flag mark, lordship, X.
you are giving the wrong date of the Lozima court order. It was 21/7/2023.
Lordship,
Heard
Wait.
Mr. So-and-so Learned Council for the petitioner parents the Lozima court order dated 21/7/2023, which goes to show that service of notice has been deemed to be complete on respondent numbers 4 and 5. However, it appears that none has appeared for the respondent numbers 4 and 5. Mr. J. Learned Additional Senior Government Advocate Assam has appeared for respondent numbers 1 and 3, and Ms. G. Hadarika, Learned S. Revenue Department Assam for respondent number 2. In view of the above, registered to verify whether this matter is ready as regards service, and if so, whether any counsel is appeared for the private respondent, for the respondents 4 and 5, and thereafter list this matter in the appropriate column.
highly understood.
Lordship. I plead your lordship. Lordship, in this matter, I was directed to file an affidavit. The affidavit has been gone for vetting, your lordship. Lordship, may kindly fix it after a week, your lordship. I'll file. Also, vernacular documents are there.
Mr. S. J. Learned Council is present on behalf of the writ petitioner. Ms. N. Godolay, Learned SC Revenue Department, Assam, submits that as per the order of this court, affidavit on behalf of the department has been prepared and the same has been sent for waiting. As such, 2 weeks' time has been paid for, bringing the affidavit on record. So the prayer is not opposed, same stands allowed. Let this matter be listed accordingly.
I'm for one.
Mr. J. Henry, Learned Council, Learned Government Advocate Assam is present on behalf of the respondent numbers 1, 2. Mr. Saikia, you are appearing for the Assam Society. Mr. R.C. Saikia, Learned Council is present for respondent number 5. J. Henry for 2 to 4. Yes.
Obliged.
May I please look? As per the office note dated 7/9/23, we have taken step to respond number 3 and 4. So service is awaited.
Heard Mr. Chetri, learned counsel for the petitioner, also heard Mr.
For 2 and 5 lots.
Arun Chandra, learned senior government advocate, Arunachal Pradesh, appearing for respondent numbers 2 and 5. Ms.
One,
A.
my lord. On one, respond number one.
Ms. A. Gayan, learned CGC is present on behalf of the respondent number 1. As per the office note dated 7/9/2023, service report on respondent number 3 and 4 are still awaited. As such, this matter will be listed again after 4 weeks with appropriate note on the status of service or notice upon respondent numbers 3 and 4.
Much obliged.
May I please, Your Lordship? Lordship, this application has been prepared for allowing the applicant number 1 to discharge this.
All right, we'll take it up in the second half. What is this item 52 hearing matter? Who's there in this case? Not 52, the
And the steps
53.
has been taken and already 12 is PRT is appeared.
Item 53.
52, my lord.
I for 53.
Hearing, ready for hearing.
I'm ready, madam.
Huh?
I'm ready. I don't know the other.
All right, we'll see that too then
My lord, 52, that can be.
at 2.
Well, 51, I need some time for filing objection, my lord. Your lordship fixed it at 2, but I would have prayed for time for filing objection.
Achha, all right, then you wait, I'll pass orders. Yes. Which is the next item, 51?
51.
What is this IA about?
Lordship, very limited purpose for allowing the applicant number 1 to discharge as a function of president, who is already been removed.
Very small, simple prayer.
Simple prayer.
But you will file affidavit.
Day to day.
All right, I heard Mr. M.K. Hussain, learned counsel for the applicant, peruse the prayer in this IA. Mr. J. Avedin, learned counsel appearing for the respondent numbers. Opposite party numbers.
7.
7 writ petitioner, my lord.
Opposite party read petitioners 10 days time. File objection opposing the prayer made in this IA. In view of the above, let this IA be listed again after 10 days so as to enable the opposite parties to file objection. Mr. R.K. Devnath, N.K. Devnath, learned standing counsel, PNRD Assam is present on behalf of the official.
Lordship, any date may be given. Panchayat is suffering, Lordship. Panchayat is suffering, Lordship.
The Panchayat is not suffering, officials are handling, my lord.
Video
is handling.
18th October, yes. Date has been given 18th October.
Well, steps has been taken, my lord. The private respondent 12 already made his appearance. And so far the respondent number 1 to 6 that is also served and by the rest of the.
Who is appearing for 12?
I am for 12.
Achha, heard Mr. Mahant, P. Mahant, learned counsel for the writ petitioner. Also heard Mr. S. Sharma, learned senior counsel assisted by Mr.
And Brahma, lord.
N. Brahma, learned counsel who has entered appearance on behalf of respondent number 12. By referring to the office note, Lojima Court order dated 12/9/2023, Mr. Mahanta submits that this writ petition is ready as regards service. Is it? Mr. J. Hendik, learned additional senior government advocate Assam is present on behalf of the official respondent. In view of the submission made at the bar office to verify and list this writ petition in the appropriate column. Any urgency?
No, my lord.
After the puja vacation. By reflecting the name of learned counsel from both the sides.
There is an interim order, my lord.
Interim order passed earlier to continue. Yes.
For hearing item 53.
Yes. What is this matter? You are ready?
Lordship, my lord, I have received my lord that instruction, my lord, that's my lord, I have to go to it. But sometime maybe my lord required to go for it. The old record.
Next Thursday, madam.
All right. I heard Mr. R.K. Das, learned counsel appearing for the writ petitioner. A.K. Das, sorry. Learned counsel appearing for the writ petitioner. Also heard Mr. J. Hendik, learned additional senior government advocate Assam, who submits that he has received the records, but has not been able to go through the same so as to make submissions before this court. Ms. A. Gayan, learned CGC.
On 6 and 7.
Central government. And CGC is present on behalf of respondent number 6 and 7. And Mr. S. Datta, learned standing counsel, Revenue Department Assam, is present on behalf of respondent number 1.
Madam, one small prayer. One particular counsel from the government should be, interested with this case. Because every day they change, it becomes problems for us.
We'll take care of it. He will be there. On the request of Mr. J. Handik, learned government advocate Assam, the party just see who is. Let this matter be listed again on 5th of October 2020.
No, 5th of October, I will not be available. because-
When?
A bit earlier than that, man.
This week it is not possible. You choose a date.
Yes, I had, yes. I did.
Loss.
No, that's not a bad. No, that's not.
What was it?
No, that's not a
10th,
All right. 10th of October 2023 as a fixed item. It is made clear that in view of the, huh?
I'll not be available on 10th, my.
Yeah, going for holiday.
No, my lord,
When?
for Kohima bench, my lord. I have case
Kohima
in
bench.
this time.
11,
11, yes, 11 month.
11 or 12.
12 month.
12th
Yes, my
12th of
lord.
October. In view of the urgency expressed in the matter by the petitioners council, it is made clear that no request for adjournment made by the respondents council will be entertained on the next date fixed.